Well, I think I'll just let you carry on and I'll ask the questions at the end.
Certainly, Sue. Or as I go.
I'll try and answer them halfway through. So
certainly. So in paragraph 4, I start briefly speaking about the merits of Mr. Shemmy's request. In my submission, Sue, this does also set Mr. Shemmy's submission apart a bit from, even if not the plan changes that you presided over, but some of the plan changes in this process, because many of them will come with the jurisdictional argument, but not have evidence on the merits of adding a wee bit in. In this case, I submit that the merits have been favourably addressed in the Section 42A report, and also in the various expert briefs provided by the applicant's witnesses. I set out in paragraph 5 the particular.
Just let me just.
Sorry, sir. I set out in paragraph 5 of my submissions the paragraphs that are particularly pertinent from the Section 42A report. I know that it does not identify any particular concerns arising from a merits perspective, and conversely, it concludes that the inclusion of Mr. Shemmy's land will have positive outcomes for urban form, and that is mainly by regularising that boundary so it's not stepping in again. It notes Mr. Shemmy's request is an exception in terms of scope and merit as compared with the other 3 blocks within the Shan's Trents Road corner, and that's the point I was touching on earlier, sir.
Well, what do you come in to discuss what distinguishes it from the others in that line?
The principal distinction merits-wise is it's where it sits.
In other words, you're saying it's got
in the boundary.
3 out of 4 boundaries that are, and yes. There's only 1 boundary that's got a rural.
That's right.
That's your main point.
Yes, it is, sir.
Just.
And the inclusion of it fills in the gap.
Sorry, what was the next thing?
Inclusion of it fills in the gap created by the second step down in that boundary.
Oh, yes, I see what you mean.
So I know we're referring to the aerial, but the officer report shows the colours quite neatly there.
So I've sort of struggled a bit with I know that from fairly long experience in dealing with these sort of things, that there's a temptation, isn't there, to want to have sort of regular shapes when you're doing zoning, but sometimes I wonder whether that's sort of got any merit or not. And yesterday there was a whole lot of discussion and evidence about the question of leapfrogging, for having, urban zoning,
yes.
And then leapfrogging rather larger lots, and then starting again with these. So,
yes.
So that there are questions about how strongly that is a matter in favour of this. But I see your point is that I get your point.
Yes, it is different because of where it sits and what it can achieve on its own. I do recall the officer report concluding that probably, in its words, this was suboptimal in some respect without those blocks in it, without all of them in it. But in my submission, this improves that situation, even if just a bit. It's still an improvement.
Thank you.
Paragraph 6, I note the relevant witnesses in the applicant's team have included evidence to the effect that their conclusions are unaltered if Mr. Shemmy's land were also rezoned. Largely, they have done this by reference to the approximately 12 hectares of land within the entire block, rather than just Mr. Shemmy's land. only 2.4 hectares, I submit the inclusion of Mr. Shamie's land would not create any discernible difference in potential adverse effects or costs, and would create some benefit in terms of urban form and planning logic. So that's all I was going to talk about in terms of the merits, and then I was going to proceed to the jurisdictional arguments. The reasoning of the merits really have been addressed by the applicant's evidence and the Section 42A report.
I made it clear yesterday, I just should make it clear to you, Mr. Shamie, that as you'd expect, any comments that I make are not to be taken as indicative of any view at this stage, but I will obviously be asking things that may suggest a view, but I haven't. They're in the context that I'm testing what's being said. So your position is that really there could be no discernible difference on merits between PC 68 and the Shamie block, because for the reasons you've expressed,
yes.
And that therefore, if it is, the two issues are going to be A, whether PC 61 should be approved by me or not, as the first issue, and you say secondly, well, if that's the case, then Mr. Shamie's block should be approved, but of course then there are these jurisdictional difficulties which we're just about to talk about now, i.e. whether or not I have jurisdiction, and B, whether I should include that block when it wasn't included as part of PC 68.
Yes, that's it in a nutshell.
Just carry on, yes, thanks.
So, turning to that jurisdictional issue, paragraph 7, I've largely already spoken to you about that. The last sentence there, I quote from the officer report, where it is described as effectively squaring up the stepped northern edge of the plan change site. This item of relief has been characterised.
Sorry, that's not a jurisdiction point, is it?
No, that's a description of what it would be. So that paragraph 7 is just, so what was it looking to add in summary? That's how it's been described in the officer report. Then in paragraph 8, I submit, or I set out that this has been characterised as a Me Too submission. And whilst this is probably a reasonable descriptor, I know not all Me Too submissions are created equal. Whether a submission is on a plan change can raise questions of irreducible simplicity, but which may not necessarily be easy to answer in a specific case, and that's from the Prebbleton decision. In the case of Mr. Shamie's request, it is submitted the question is mercifully simple to answer for the reasons set out further below. So I'm just making the point there that these scope arguments, they all come down to the same test, but they can be incredibly difficult to apply depending on the circumstances. And my submission is that here we actually have a fairly simple case to apply those tests to the case.
So that's the first leg you're talking about?
Yes, for both legs, but certainly in terms of the extent
the reasons for them are different. The reason for the first one, you say, is that because it's bounded in the way that you discussed and talking about the gap, etc., you say that it is on the plan change. In other words, it fulfills the first criteria, and it's just called part of the Palmerston North case.
Yes, that's what I go on to say. So we don't have many of the complexities that we do often face around that, whether or not it actually is directed toward the plan change, whether it is on the point that alters the status quo. So, at paragraph 9, I set out some general legal principles. I'm not sure, sir, if you want me to go through those. I know you're very familiar with them.
Well, if you feel free to do so, but let me just summarise it by saying that I have taken it that probably the most relevant case is the Palmerston North City Council case, and that the law is correctly summarised in that. It's pretty thorough. It's a fairly thorough decision, and you can take it that unless I hear otherwise from you, that is the law that I will be applying, that in the Palmerston North City Council case. That, of course, was a case which is not exactly on all fours. It's obviously got different merit considerations, but it does talk about the rezoning of another lot that wasn't originally mentioned.
Yes. Yes, so I have focused on the motor machinist case in the submissions as well. And the reason for that is, so the motor machinist accepted and applied clear water. That is still good law and the leading law on scope in my submission. A motor machinist took that and applied it. It is often cited now as probably being the most restrictive of the cases concerning scope, motor machinists. So councils tend to rely on that, in my experience, they tend to rely on that case to put an end to Me Too submissions. Therefore, I would describe it as probably the most conservative case on scope that there is at the moment. And I had cause to look at this at the end of last year and noted there are about 8 environment court decisions that have followed motor machinists, and all of them show a real grappling of the environment court with just how tight that case is compared to where things were heading under just clear water. What I have done here, sir, for Mr. Shamie's submission is we've applied the motor machinist case because we can satisfy what you need to under there. That is part of why I would describe this as mercifully simple. I don't need to be talking to you about the nuances that may have to be found within that case to get other rezoning requests through, because even applying that case, even taking the most conservative approach, Mr. Shamie's submission quite clearly comes within the incidental or consequential changes that are still allowable under the motor machinist
So you
case.
say taking the most conservative approach, what's your position?
Yes, so taking the most conservative approach, which in my submission is outlined in the motor machinist case, the submission of Mr. Shamie still comes within that case in that category of allowable extensions, which are described as incidental or consequential.
Well, just on that point, I've been asked yesterday to consider that there are 2 small, very small blocks, the corners of the plan change, which I've been. It's been suggested to me that I should regard them as consequential. Now that's a different issue, the consequential issue, from whether it's within scope and dealing with it in this. So are you saying that I should also look at the question of whether it's it could be qualified as a consequential amendment or not?
So I think it's more properly characterised as an incidental amendment.
Well,
but I have used words all consequential as well, because when there is a case that I have referred to in my submission, the Tussock Rise case from the Environment Court in Queenstown, in paragraph 76, and I can get this case to you electronically if you don't have it already in,
yes, I'd like that.
in the materials. It deals with a whole bunch of issues that aren't relevant to your consideration here. But it cited rezoning of adjacent lands as being an example of the kind of consequential or incidental change that would be allowable under the motor machinist test as well.
Right, look, I'll let you carry on. I think so you wrote in paragraph 11. I understand the point you're making.
Yes, and I think the only point, Sarah, if I can, that I would also make in respect of that Tussock Rise decision is that it is referring to a case of justice, which is in the Albany North case, where he really looked at what kind of a spatial change would be incidental or consequential. And that's probably the best case to look at for an understanding of the extent to which you might, for example, call those little areas consequential, and whether or not there be a distinction between that and the type of rezoning Mr. Shamie seeks here, which is an incidental part of this southern treatment to Prebbleton.
You'll make them available.
Can do so.
Thank you.
Perhaps I can just take to paragraph 15 of my submissions now.
Just pause. Yes. Probably the correct sequence is for me to consider whether this is incidental or consequential. Because if I found in your favour on that, and I hasten to add, I'm not in any way commenting upon whether or not the plan change itself should be approved, but leaving that aside, if I were to find that it was consequential or incidental, then I wouldn't need to go any further, would I?
Nice.
I mean, the question whether it's in scope then is inevitably regarded as being in scope because it's incidental or consequential. But that's the issue I've got to decide. So I understand that.
Yes, no, that makes sense.
Yeah.
And perhaps just to round out my submissions on that, in paragraph 13.2, I note there a quote from two cases, two environmental court cases that followed the mud machinist case. One of them said in the end the jurisdiction issue comes down to a question of degree and perhaps even of impression. And Sarah, the reason I draw that to your attention is because when you look at, or if we look at the aerial photograph that you have in front of you, and we're talking about impression, and we look at number 17, Mr. Shamier's land, and then we look at numbers 19 and 39 down the bottom and south of Hamptons Road, the impression is quite different. Mr. Shamier's land is clearly within the parcel of PC 68. The land to the south of Hamptons Road just looks a bit out on its own. In my submission, that's what the Environment Court has been looking at and still does look at post-mud machinists. It's just say, well, what is the instinctive reaction to this? And 13.3 in my submissions is another indicator of whether or not we are talking about a permissible, incidental or consequential change. And that is, does the submission seek to alter the higher planning provisions, the objectives, for example, or is it only concerned about implementation? And here, of course, Mr. Shamier is not seeking to tinker with anything apart from equivalent treatment for this land. My point at paragraph 14 is another quote from a machinist where they qualify the type of incidental or consequential changes that might be permissible by saying, provided that no substantial further section 32 is required to inform persons of the comparative merits of that change. And in my submission, the section 32 report or the cost benefit analysis would look exactly the same whether you have Mr. Shamier's land in or not. And that comes down to the submission I made right at the beginning about the merits, is that there is no difference in terms of the potential adverse implications. There may be, though, an additional benefit in terms of urban form and just planning logic and coherence. At paragraph 16, I set out the legal principles regarding fairness and how that needs to be considered. Again, I don't think you need to read that. So the acid test remains that set out in Clearwater. whether a planning instrument may be appreciably amended without real opportunity for participation by those potentially affected. And here those three submitters in the same corner as Mr. Shammy, including his direct neighbour, are involved in this plan change.
Well, just, yeah, I'm not sure you're going on to deal with this here, but I just wanted to look at what the expressed view of the others is, i.e. 32, 30 and 6. Can you tell me what their expressed view is, and either in terms of any submissions made, or can we go through them, each of them? So let's just start with number 32, which is the Holder property.
So my understanding, sir, is that each of those three submissions were the same. Mr. Clays may need to correct me if I'm wrong on that. And each of them sought decline of the plan change. None of them asked for their land to be rezoned in the way that Mr. Shammy's submission has. I understand that they are appearing at the hearing, or at least Mr. Cheney.
Mr. Holder, I think they all are, yes.
Yes, so you will have an opportunity to speak
Yes,
to them. The best I know at this stage is the evidence that Mr. Chen pre-circulated for this hearing. And from what I understand from the evidence, and I will be corrected, no doubt, if I'm wrong, is that they would like the same situation as Mr. Shammy asked for, which is if PC 68 is to go ahead, that they be rezoned in the same way, other words that are used.
Do you have a position in relation to the question of whether, as a priority, I should be considering all of those properties? In other words, how did your position is that Mr. Shammy's property is distinguished from the others because of the boundary issues we've talked about?
Yes.
But are there any other factors which distinguish it from those other properties?
From a merits perspective, it is surrounded by a road and two boundaries of plan change, but also being in line, if you like, with one of the boundaries that is already proposed by PC68 is a very simple, clean insertion or inclusion. The other three properties do not have that. So this property fits in very well with PC68. You wouldn't even notice it, if you like. But the other properties are different shapes and they touch each other to a much greater degree. But Mr. Shammy does not have any, Mr. Shammy did not further submit on those submissions and has no particular concern as to the outcome of that. His concern is more about ensuring that if the land that adjoins his property is rezoned, that number 17, his property, is also rezoned. I would note neither of those three submitters opposed Mr. Shammy's submission either.
Okay, so his position is that is he neutral about the question of whether they are to be rezoned?
Yes, sir. Of course, sir, and Mr. Shammy's submissions are not speaking for or against the rezoning of those other properties. There are, of course, other mechanisms available to you should you get to the point where you see merit in them being resigned, but you simply don't have a submission seeking it.
So we're up to 18, are we? Or
No, sir, it was just, yes, we are up to 18 in my submissions.
right.
In this part of my submissions, I discussed the breadth of alteration and why the submission of Mr. Shammy is directed to that. I don't know that you need to take you through it too carefully. At paragraph 18, I have identified the part of the officer report that describes concisely in my submission the breadth of PC 68, and particularly the last sentence where it talks about the fact that PC 68 examines the appropriate formation of the southern edge of the Prebbleton township. In my submission, that means that really we're dealing with the plan change that goes from here up, and Mr. Shamley's property is here. Whereas the blue property that I referred to as being quite a useful illustration of what might not be available sits just here. And in joint style,
Perhaps just
paragraph 19.
talk me through the rest of that, and
Yes.
then I've got another question I want to ask you.
So paragraph 20 of SmartAct, the submitter, Mr. Shammy's submission responds to and directly addresses the change to status quo proposed by PC 68. It relates to part of the area between the existing southern edge of Prebbleton and the proposed one. In this sense, it is proposing to infill part of the gap in urban form resulting from PC 68. It responds to the fact PC 68 does not propose to directly alter the regime applying to Mr. Shammy's land, but that it will undoubtedly affect it by markedly changing the planning regime around it. The Section 42A report concludes, Mr. Shammy's request is therefore arguably consequential to the substantive outcome sought in the plan change, and further, the relief sought is sufficiently modest in scale that their inclusion does not threaten or unduly expand the scope of the plan change. Mr. Shammy respectfully concurs with the Section 42A assessment in this regard, with one amendment. It is submitted the change sought is consequential, as opposed to just arguably. This is supported by paragraph 150 of the officer report, which considers rezoning of the gap to ultimately be inevitable. In addition, it is noted Mr. Shammy's land would comprise a mere 3%, approximately, of the overall rezoned area if added to the 67.5 hectares currently proposed for rezoning. In this sense, it is genuinely incidental and remains so even if the entire 12 hectares of gap is rezoned.
%15%, right, okay.
Yes. I think my maths is correct on that. Turning to the issue of procedural fairness, number 23, it is difficult to conceive of a situation where a person might be potentially affected by Mr. Shammy's request, but not PC 68. This is because Mr. Shammy's request is both incidental or consequential, such that it represents a very small risk in terms of denying potentially affected persons an effective response to additional changes in the plan change process. Now that came from my machinist case, sir, where the court noted that if it is actually incidental or consequential, it is very unlikely that there will be a risk of prejudice to anyone. And secondly, Mr. Shammy's request is not out of left field. Rather, it is submitted to be entirely predictable and readily foreseeable. As noted in the Section 42A report, all 4 property owners at Corner of Shands and Trent's Roads submitted on PC 68. This included the landowner immediately adjoining Mr. Shammy's northern boundary, being located at 687 Shen's Road. The fact these landowners each made original submissions supports the submission. There is no risk of disentitlement if you accept Mr. Shamie's request. Mr. Shamie sought rezoning as an alternative relief. Upon investigating the summary, this would have been very clear. And I've set out there how Mr. Shamie's decision requested was summarised. Decline the plan change as preferred decision. If the plan change is approved, then also include 701 Shands Road to be rezoned for residential development in the same intensity as PC 68. The other three corner submitters sought rejection of PC 68. The evidence of submitter 6 now discloses a desire to have the remaining three properties in the corner rezoned also if PC 68 is granted. In my submission, this further corroborates the officer's conclusion that rezoning of all gaps is ultimately inevitable. In conclusion on this point, it is submitted as incomprehensible that a person would be concerned with the zoning of Mr. Shamie's land, but not already involved in the PC 68 process, and therefore not interested enough to look at the summary of decisions requested. In the event the notified PC 68 land were rezoned, in my submission, it is appropriate, lawful, and fair that Mr. Shamie's land receive equivalent treatment.
I think if you've got I don't know if you've got a copy of the Palmerston North case available, but the critical passage seems to be paragraph 88, where the judge says the real concern is in terms of, I'm talking about in terms of the rights of the other three, is whether or not they may have taken another step had they known about the position. And in that case, he said, well, look, he said, this leaves me with a real concern that persons affected by the proposed rezoning would have been left out in the cold. So really the issue I've got to decide, and as I say, I'm leaving aside the question of whether the change should be approved or not. Then I'm just assuming that I were to reach that view, and as I say, nothing is to be taken out of that, I would have to consider whether the others are left out in the cold. Now, one issue may well be Mr. Chen appears to be changing his position. He's going to give evidence, so we'll find out about that. Saying, well, he supports the rezoning of his own land. Now, it may be, and I don't know whether that obviously if the attitude of the others to rezoning is obviously going to be an issue. And the question then becomes, well, would they have taken any other steps in the light of paragraph 88 of this decision and looking at it? Your position is no, they wouldn't have because they knew about it.
Yes, yes, and Sarah, just looking at the paragraph that you refer to, in my submission, it would be highly unlikely and surprising if those submitters did not read summary of decisions requested, given the stance they took when the plan change was first notified, and given the fact that there weren't a lot of submissions. So this is not like reading a summary on a proposed plan. This is a very discrete summary of submissions.
So you're saying they're not left out in the cold?
They can't be, so it would be my submission. It is difficult to imagine how they might be, and to date I have seen no evidence from any party suggesting that they were. And in fact, I see evidence from Mr. Chen telling me that they were well aware of what Mr. Shamie was asking for, and actually they now think that's probably a good idea too.
One other, just thank you for those helpful submissions. It's not an easy issue, to be frank. I don't think, but I've one of the points I wanted to ask you about was your submissions have all been on the premise that the change is approved, but the primary relief that Mr. Shammy sought was he wants it to be declined. Do you wish to make any submissions about that, or is his position now that he would prefer it to be approved on this basis, on the basis that his land is to be approved?
So I do not have instructions to present any submissions regarding that. The submission remains as it is, so the relief has not been withdrawn. About the submissions that we come to you with today simply relate to whether or not you could do that if you rezone the rest of the land.
One of the issues that arose, thank you, that's helpful. One of the issues that arose yesterday, and I'm not sure that you're aware of it, is that the Selwyn District Council in a variation report has resolved that if I were to approve this change, recommend approval, I can't approve it, recommend approval, the council would then consider whether to accept my recommendation, but would not go as far as formally approving it under clause 7. If you look at the variation report, it's that requires the Selwyn District Council to promulgate a variation, and it's already resolved that it is going to promulgate a variation to cover the Enabling Act, the 3-story business. So it's going to have a variation, and what is proposed is that if this particular change were to be recommended by me and the council to accept my recommendation, then that would become part of the variation. And rather unusually, as I put it yesterday, it would appear that then that variation will be publicly notified and everyone would have another chance to make submissions about that variation. Now, that, I have to say, the position that, first of all, I believe that what I'm saying is correct, and if it isn't, well then I'm sure I'm going to be reminded of it. If it is correct, then there are issues about, there are all sorts of issues which arise in relation to it, because in fact what's happening is the submitters would be having 2 bites of the cherry. They're coming to make submissions to me, I then make a recommendation one way or the other, and if the recommendation is to approve the change and the council accepts that, then the submitters, it seems to me, would have another opportunity in the context of the notified variation to say, well, we're not happy with it. Now, the view I've got, the tentative view I have, and I hasten to add it's tentative, is that that's not my concern, that my duty is to consider the change as put to me and to make a recommendation. Now, what happens to it after that is really not to do with me. That's how my view is at the moment, that I shouldn't get tied up with what the consequences of that are. That's really not a matter for me. I'm not advising the council about those issues, obviously. I'm a commissioner, I'm an independent commissioner. And so that's what I propose to do. I'm very happy to hear from Mr. Cleary or from you or anyone else, the submitters as well, of course, as to whether the stance that I'm taking is correct, in other words, whether the premise is correct, i.e. that there will be a variation, etc. I'm just simply reading the variation report. But you may have care to have a look at that just to see whether there's anything that I'm omitting, because it is, I don't see it at the moment as being relevant to my task here, but what I'm saying is that you ought to be aware of the consequences of it. In other words, if the change is approved, it will not be able to be put into effect and made operative until after the variation has been notified and there's been hearings of that, a decision's made and any appeals have been resolved. Now that's as I see it at the moment, and so what I'm suggesting is that if you have any, and I reserve leave to anyone, including submitters, of course, because I haven't heard from them yet, a lot of them, to make any submissions they want to about that point. but on the premise that what I'm proposing to do is to simply proceed to make a decision, make a recommendation one way or the other.
Mm. So I haven't looked at that report. And
Yeah, well, I don't expect you to comment on it now, but I reserve leave though for you to raise that. The other point was it would be helpful to have copies of all of the decisions other than I've got the Palmerston North decision and I have the Clearwater decision, and also, yes, the Clearwater decision and the Palmerston North decision. I've got copies of those, but the others that you refer to,
yes.
Is that going to be a problem or not?
Not at all, sir. I have got a few.
Perhaps if you could just put them when so you have the tabs relating to the footnotes. So I know that, for example, the footnote 19 is the Queenstown case. Well, then I'll look at tab 19 so I can quickly get it.
Yes, and what I might do is I haven't actually referred to the Albany North case in my footnotes, but it is referred to in paragraph that I have footnoted, and that does deal with the incidental consequential changes. It's a different context, but that may be useful, so I think if I include that as well, that could be of assistance to you, and perhaps more so when you consider other parts
Perhaps
of the area.
If you're able to do it by next Monday, it'll be helpful.
Yes.
So I was going to suggest to her that we could have consolidated case book in terms of what cases relied on.
Or what do you put a combined book? I agree. That's a good idea.
So Ms. Limmer can provide me a copy of.
Yes, well, thank you very much for that. That's very helpful. So Mr. Cleary will prepare a sort of a book of authorities. I suspect it might be quite thick, actually.
At least 2 volumes.
But anyway, it's better like this is a significantly important issue, and I want to make absolutely certain that I look at it really thoroughly, as of course with the rest of the change. Just give me a second, Willie. I just want to have a look through. Well, you just. If I'm right about the process, then it seems to me that it would be that any submitter could make a submission in relation to the variation saying, I want my land included.
Yeah. Well, if it was
If that is the
variation,
position.
yes.
Anyway.
And as for the case law that you would have seen on scope, there is a note of caution from the Environment Court about leaving too much the idiosyncrasies of the person that promotes the variation in the council in terms of trying to restrain scope so narrowly that no one can do anything, which is what I would imagine may be the reaction to something like that, to try and limit the amount. It's not an easy task either way. Don't think that helps too much.
Well, it may be that, and again, I emphasise I'm not making any comment about whether the change is going to be approved or my recommendation will be to approve it or not. Leaving that aside, the issue may well not be whether there are some merit-based issues, as you say, in terms of the line, etc. in your case. But you can take it that I've been looking pretty carefully at the question of making sure that any other people who are affected are not disadvantaged by any step I take outside the change itself.
Yes.
Just let me have another look and see if there's anything else I want. I may actually issue a minute about this variation issue because I think it is pretty important. But just that I get it, and it may cover any other matters that I want further information on. But it'll be after Monday because today we're going till 1 o'clock today or whatever. Then because of the COVID difficulty, we're then starting again next Monday. So if I could have that combined book, by next Monday, it'll be helpful. If you can't do it by then, well, as soon as possible after that. Because I'll have to sit down after that and consider the position.
So there was one question you asked me in terms of how this alternative relief fits in with the primary relief, and I've just spoken to Mr. Shenny to get clear instructions on that. And the best way to describe it is that Mr. Shenny is now neutral as to what your decision on that is.
Well, I've noted that.
Yes, like that's what I was trying to say, but I'm not sure placed it
So in other words, that's contrary to the submission, isn't it? But it's now neutral.
It's now neutral, and the prime submission is, but if you are going to approve it, sir, please include this land. I think I bumbled my way around, but that's sorry, sir.
Is he neutral to it, provided that if I do make a recommendation, his land will be included, or is he neutral regardless of that outcome?
He is neutral to whether or not to grant PC 68.
Regardless of whether or not.
No, but he is, if you are to grant it, he is not neutral as to whether or not his land goes in. He would, the request is that his land is included. And that is why the effort has been put into ensuring both merits and legal issues are addressed. Mr. Shenny lives here at the present time.
Yes.
Yes, well, thank you both very much for presenting your case to me. I'll consider that, and you're free to stay and listen to the rest of it. Right, well, Mr. Wakefield and Mr. Langman, I have now.
Good morning, sir.
Mr.
Good morning, sir.
Well, I'll hear from Mr. We've got them in the sequence, Mr. Wakefield and Mr. Langman. Is that the convenient sequence?
That seems convenient to me, sir. Happy to proceed on that approach. Is this coming through loud and clear, by the way?
I'm sorry, this is not going to be very successful unless I can hear what you're saying.
Is this, can you hear me at all? Is this working?
Right. Just pause for a minute, would you? Yes, look, I'm just going to take a 5-minute adjournment. So if we can return in 5 minutes, I just need to discuss a matter. Thank you.
Could you hear me, Marcus?
Yes, I can. Yeah.
Bizarre.
Loud and clear.
All right, good to know. We probably shouldn't talk about this on.
Did you have any, there's no evidence, Mr. Wakefield?
His submissions are just been sent through, I think.
Yes,
You said it just been sent through?
yes, his summary.
Mr. Wakefield, can you hear me?
Yes, sir. Good morning.
Good morning. The reason I asked for the adjournment was that I don't appear to have any written material from you. Is that right or not?
No, I emailed some submissions through to the administrator this morning, who I understood was able to print them and provide them to the persons in the room today. That was to Grace, and I flicked them through at around about 8 o'clock this morning. So hopefully they've made their way to you, or they can.
I haven't got it, and I mean, it's I think it's, I don't want to be taking a longhand note of everything you say when that's been said. So we'll have to just have a short break to enable me to receive that document.
Look, absolutely. I'm more than happy with that. I do think it makes sense.
We haven't got any printing facilities, I think, in this at the moment, so it might be half an hour or so.
I sought to clarify this yesterday with the administrator and understood that that was fine to email them through. So apologies if there's confusion on that.
You should go first, and Mr. Langman should follow. I'm not probably better to do that. Are you happy with that, Mr. Langman?
Yes, that's fine.
So I think what we'll do, we'll just, if you don't mind standing by, just go and have a cup of coffee or something, but we'll need to wait until those submissions arrive, or until that document arrives. I've got Mr. Langman's document. I've had that, of course, for some time.
Yes, that's right. That's right.
Right, so shall we just, can you just stand by, and as soon as the document comes, I'll then reconvene the hearing?
Certainly.
Another way to deal with it, or?
So there won't be printed copies on site.
What's that?
There won't be printed copies.
Yes, yeah.
Sorry.
There was someone, I think we're getting a printed copy, are we?
Well, we're just gonna figure out a way that we'll bring it up on one of our laptops and you can read it from there. And I'll be sending it through to all the submitters so that they'll have a copy on an electronic device.
I just wanted a copy that I can write, you know.
Oh, okay.
So really, it's not very satisfactory. I haven't got an electronic, I haven't got my laptop with me because I thought it would have been done.
Okay.
Yeah.
I'll need a hard copy.
I'm sorry, the other option is someone at Snow Council who can physically print a copy. You can also drive.
You're on process, so I can just go to the office.
Excuse me. Excuse me.
You happy to do that?
Yeah.
Thank you very
I'll
much.
shoot down by the time I get back.
We might need a few, can you do
I'll
a few?
do 10 copies.
Yeah, that's great. Thank you.
Is there any other ones that are?
Excuse me. Hello.
Mr. Langman's statement.
Do you have a summary?
I haven't got a summary, no.
So against the legal submissions and Mr. Langman's summary that need to be copied.
So in terms of my summary, there was no.
Mr. Wakefield, is yours a document a summary, or is it a summary and the primary document?
So mine will be legal submissions, and Mr. Langman didn't identify a direction to prepare the summary. So his summary is in effect the opening stanza of his evidence, which has been pre-filed with everybody. So he may have some updates to that, but the first 12 or so paragraphs are effectively his summary. Yep.
Right, I understand that. Thank you. Right, well, we'll just wait till this to come, and this shouldn't be very long.
Apologies for this, sir. I didn't mean to cause any unintended delay to this proceedings.
We'll deal with it best we can, but I think that it's important that I've got it in front of me, otherwise I'll miss something, and I don't want to.
Excuse me. Hello, can anyone hear me?
Yes. So
Yeah, I'm the next one. I'm Mr. Chen, Frank Chen. So if you do not mind, I can do it first because I only take 15 minutes. It's just an option.
So Mr. Chang would like to go before the city.
Oh, okay, well, that's fine.
That's absolutely.
Well, why don't we do that? Then we'll do that now.
Yeah.
Thank you.
Yeah, so is that all right? Can you hear me clear?
Yes.
So good morning. As I said, my full name is Xiaozhang Chen. I own the property of 330 Trains Road. And I believe you have 4 pages of evidence I submitted.
Just pause. I'm going to find the other document that you
Okay.
that you sent in. Yes, thank you. Would you'll speak to the document which I've received, will you?
Yes. I think there's 3 documents from the submitters. My one is one of them. It's just called evidence for the PC 68. Oh, it's a PC 680006. And my name is Xiaozhang Chen.
You're just reading from it?
Sorry?
I have your evidence, and I'm looking at it now. You got to just take me through that.
Oh, okay, yeah.
Speak into the microphone clearly, would you? Because I'm having difficulty hearing you.
Yes. Okay, so I will just follow the evidence then. The first issue I want to raise is the proposed rezoning. Actually, I was in the previous one. I heard the lady talk about Mr. Shami's property. And the first one, proposed rezoning, is more about that, compare my property to Mr. Shami's property. I strongly disagree with Mr. Clears on the point 145, 143 to 145 in the council's section 42 report, because that is the section about these 3 or 4 properties on the corner of Shanks Road and Trans Road. So Mr. Clears listed 4 properties. There is a map on the second page, if you can have a look.
On the second page?
Yeah. So the map shows A, B, C, D. That's 4 properties we are talking about. My property is number A.
Your A.
Yeah. And Mr. Shami is number D.
Just pause there, please.
So as you can see, these 2 properties, their location to the PC 68, there's no difference. Mr. Clears mentioned one of the evidence for his recommendation. Sorry, I need to mention the recommendation from Mr. Clears. So he recommend that Mr. Shami's property is to be rezoned along with the other areas in PC 68. And the rest 3 properties, including my one, which is A, B, C, are excluded from the proposed rezone. Personally, I think that's ridiculous. So the first one, he mentioned the evidence is the distance of those properties from the urban area, which you can see from the map. Basically, the distance are the same. You know, we are at the same corner. Mr. Shami's property has 2 sides adjoining PC 68, and I have 2 sides adjoining PC 68, and also the other side, opposite Trans Road, there's an existing subdivision. So basically, my property will be surrounded by the existing development or future development. 3 sides will be surrounded. Also, maybe, the other 2 properties, B and C, the owner, they are going to talk about their own properties. We had a discussion. So those 2 property owners, they are at the same, the same opinion with me. If Mr. Shami's property is to be included in the PC 68 to be rezoned, and the 3 of us, the 3 properties will be left out, that will be a very strong objection from us.
Just pause there, please.
Yep.
Just looking at your very helpful map. Your property A, aren't you?
Yes.
When you say that your property will be bounded on 3 sides by the proposed change if it's approved, where are the 3 sides? I can see
2 sides. 2 sides.
2 sides, isn't it?
Yeah, 2 sides. So you can see there's 2 sides, the eastern side and southern side. The other side I'm talking about is Trans Road, because the other side of Trans Road has been subdivided.
Oh, you're talking about the subdivision on the other side of the road.
Yes, yeah. So
Yes.
basically,
In other words, you're saying that there's only one rural boundary effectively. That's what you're saying, aren't you? With rural is owned land.
Yes. So 3 sides will be surrounded by urban development area, and the other side is adjoining these 2 property B and C. And as I said, those 2 property owners, they will have the same opinion with me. They will be very unhappy to see what happened. You know, if a PC 6 data to be rezoned and those variations to be approved, we think that's ridiculous. So maybe it's worth to mention my position on the PC 68. I understood there could be 4 options. I mean, could be 4 options on the table for you to have a look. The one option is no rezoning for the PC 68, so nothing will happen. The second one, I believe, is PC 68 could go ahead, but nothing else, not the valuation. The third option, of course, could be PC 68 go ahead, plus the valuation mentioned in the section 42 report, and also the developer's evidence. So basically, 3 properties will be left out. That's the third option. The fourth option could be the whole block to be rezoned. The whole block means Trains Road, Shands Road, Hopton Road, and also the other side is Springs Road. The whole block could be rezoned. I think any planners or most of the planners, they will agree with option 1 or 4. So the whole block could be rezoned or nothing will happen. I think that's the most reasonable solution. If the option 3 is happen,
Just pausing there. Where are you reading from? I'm sorry, I've lost you.
No, this is only my understanding. I just talk about based on, you know, just express my opinion on the PC 68 and the issue with the valuations. It's not on the paper.
I think it'd be helpful if you told me when you were referring to your evidence. I've got your evidence in front of me.
Okay, yeah.
And so if you can just say, well, I'm at paragraph so and so, you know, with the paragraph. If you want to speak, then just tell me when you're departing from the text.
Okay, yeah. So let's go to.
So you're up to you've talked about the other 3 properties. Your view is that all 3 properties should be part of this rezoning.
Yes.
Now, looking at your, as I say, your map.
Yeah.
We're going to hear, or I will hear from the submitter B and C. That's Mr. Holder and Ms. Pollard, I think. They're
Yep.
right, the 2 neighbours.
Yes.
And they will no doubt let me know what their view about this is.
Yes.
Do you know, have you had discussions with them about this or not?
Yeah, I had a short discussion, short meeting with them after I see the section 42A report and the developer's evidence. Because it's very strange that section 42A report followed exactly what the developer wants.
So you discussed it with them after you got the 42A report?
Yes.
And are they of the same view as you, as far as you're aware, do they share your view?
Yes.
Yes, thank you.
Shall we continue the paragraphs?
Yes, you're coming back to the written document again?
Yeah.
So where are we in that?
We will go to, hold on. So under number 1, proposed rezoning. So 1, 2, 3, 4, 5, 6, 7. We go to the 7th paragraph.
I just-
Yeah, so this one basically says the living quality and amenity value of the 3 properties will be significantly eroded if other area in the block is rezoned for more intensive development. So basically, we cannot be left out. That's yeah, as I said, that's ridiculous. And the integrated planning of the infrastructure in this area will be very difficult to achieve if the 3 properties been left out, because later when the 3 properties decided to have a plan change or do whatever, to subdivide, this 3 property has to drain wastewater and the flood water into the PC 68 area because of the land terrain. All 3 properties are higher than the other areas. So it has to be taken into account by the council's planner.
You say the 3 properties are higher.
Yeah, yeah.
More elevated than the rest of the change area adjacent to them.
Yes, yeah. So generally falling towards northwest, towards southeast. So it means the wastewater will drain towards that area. They have to put a big wastewater pipe to take the extra flow. And also if it's raining, the flood water will drain towards that area.
Yes, okay, thank you.
And then I refer to Mr. Chris's point 76. The report said actually the infrastructure is sufficient to provide services to the whole block. Here mentioned is PC 68 will be 820 new dwellings. If the whole block to be subdivided is approximately 1,040 dwellings. So that's in the section 42 report. So what I am saying is there is no infrastructure capacity issues preventing these 3 properties to be included in the rezoning. So there's no issue at all. Then I come to a point, I think it is much reasonable to keep the same zone for the whole block between these 3 or 4 lots. Yeah, I mentioned. Most planners will agree with this. It was surprising to see that Mr. Chris come up with such a recommendation and treat the 4 properties differently. Because no one wants to be left out. We only have 3 properties at this corner. So what I want is, the first thing I object the proposed development in PC 68 because the intensity. Before they only talk about 3,000 square meters per lots. When the developer come to talk to, I think once at a time, the developer come to talk to me, says they want to divide it into 5,000 square meters per lot. I said, it's okay, you guys, if you want to do that. But they change it to less than 1,000 square meter per lot. That is way too intense. Because most of the neighbors, they are scary to see 820 properties will be created in this area. But I do understand the council may have some plan to put more
And of course,
properties.
where are you reading from at the moment?
The last paragraph, page two, the first paragraph on page 2.
The drinking water issue?
No, the page 2 with the map.
Well, I've got you having taken me as far as the location map. Now, the next
Yes, yeah, location map, yeah.
three, and it's here, the drinking water quality issue.
Maybe,
Not in front of me at the moment.
okay, so the page with the location map. Can you see that there's a paragraph above the map?
Would you want to discuss the drinking water issue with me in paragraph 2 of your?
Are you talking about the
Is it your
drink water quality issue?
Yeah.
Okay, before we talk about the drink water quality issue, I would like to summarize the first point.
Yeah, right.
Yeah, which is writing on the page 2 above the location map. So what I say is, overall, I object the PC 68 because of the development intensity. If they want to put 5,000 square meter or 2,000 square meter per lot, I'm very happy. But now they want to put 1,000 square meter per lot for the PC 68. So I object to that one, but if PC 68 is to be approved, then I would like my property to be rezoned as the same with PC 68. Also, as I mentioned, the other 2 property owners, they actually want to do the same thing. So it means the whole block could be rezoned as the same with PC 68. So that's my wish.
Just pausing there. You want Mr. Shammy's block and the other 3 blocks that we've been looking at on your plan, all to be rezoned as part of the change.
Yes. If
I'm a bit unclear as to what your position is about. Are you comfortable with the section sizes, etc.? That you're supporting that they should be of that size?
Well, I'm not comfortable with that, but put it in this way. So if PC 68 is to be go ahead, then what we valued, the lifestyle property, everything we valued is gone because it's been taken away by the developers. If that happened, then we would rather all property to be rezoned as well, because everyone.
Are you saying that you would have preferred a lifestyle property size, but you accept if this change is approved, that there should be smaller sections, is that right?
Yes, I prefer the lifestyle property size.
You prefer the lifestyle 1,000 meter or whatever sections, is that right?
Yes, about like 2,000 meters, 2,000 square meter per lot.
2,000 square meters.
Yeah, 2,000, yeah.
But what you're saying is that's what you prefer.
Yeah.
But if if the proposed change is approved, you would accept it. Are you saying you accept then that there should be these smaller section sizes if the plan change is approved? Because otherwise you're going to be in a what's your position about that?
Yeah. For me to accept this, the only thing is the whole block to be rezoned as the same, means include my property and also the neighbor's property, these 2 properties. So basically the 4 properties to be included in the PC 68 to be rezoned as the same, that is acceptable for me.
So you're accepting then that they will have smaller section sizes if they're approved?
Yeah, I accept that.
Just pause there, please. yes, thank you. So that's your summary, isn't it?
Yes, summary of the first point.
Yes, I understand what you're saying, and your reasons for it. And I think that what's left is you're going to talk about the drinking water issue, are you, and the boundary issue, is that right?
Yes, those ones, if the whole block to be rezoned as the same, then the next two issues is gone. Because the next two issues to be an issue only because the PC68 to be go ahead, but my property to be left out as a lifestyle property, then there will be this kind of a boundary issue and water quality issues. So do we still go ahead? Yeah, for the. Do we still go ahead for the number 2 and the number 3?
Which part of your written document are you referring to now?
So now I'm going to focus on the number 2, drink water quality issue. As I said, when I talk about the number 2 and the number 3 issues, this is because if the PC68 is go ahead about my property to be left out, then I will talk about these 2 issues.
So you don't want your property to be left out?
Yes.
Right. Thank you.
So do you still want to hear the number 2 and the number 3 issues?
Well, you're going to the number 2 now, are you?
Yeah, yes.
The drinking water issue.
Yeah. So the number 2 is based on the current PC68, you know, the arrangement. They want to subdivide, but my property is not being subdivided. And my property is a lifestyle property. So the number 2 is more about the water quality supply point, drink water supply point, because when you see the map on page 4, you can see there's a circle there. In the center of the circle is my water tank. And my bore is just below that water tank. It is very close to the boundary. It's about 1 meter to the boundary. So
is your position that if the plan change were to be approved and your property were to be part of it, you'd accept then that the drinking water issue could be resolved, do you or not?
Yes, it will be resolved because
if it's part of the change, then you accept that the evidence has been given about the ability to deal with the quality of the water.
Yeah, sorry about the confusion. So if my property is to be rezoned as the same with PC68, then the drinking water quality issue is gone. And the boundary issue is gone. Is that still confused or?
Right, and so your concern though is if your property is not rezoned, you have a concern that the stormwater runoff, etc., is going to affect the quality, your drinking water quality.
Yeah.
For the reasons you've set out in this document, I've read that document.
Yeah.
And so you would want to be satisfied that there was no effect on the quality of your drinking water if you weren't to be included.
Yes. So if my property to be subdivided, then I believe the new property and my current property will connect to the council's drinking water network. I believe that's what's going to be happen. Then the drinking water quality issue is gone. Because I do not need this drink water, this well, I do not need it if I can connect to the council's network, and if I can subdivide the property.
Right, so I understand that, and thank you for that. I understand your position about the drinking water.
Yep.
So you would be looking for assurances if the plan change were to be approved and your property not included, you would be looking for assurances that the drinking water was protected. In other words, it wasn't going to have a diminished quality.
Yes.
So the last issue I think you raised is the horse training issue, isn't it?
Yeah.
In the horse training arena, and you've got reverse sensitivity concerns about that. Is that right?
Yeah.
Is that just? Can we go to Figure 2?
Yeah, Figure 2.
Now. Right, so you've got the horse training area at the very corner, haven't you?
Yeah.
And what you're saying is, well, if you were not to be included, then you would have concerns about people complaining about your activities.
Yes, I think it is a reasonable concern because it's right against the boundary. It is purpose-built horse training arena, will be noise and will be dust issues.
Right.
And also, when you see I marked the area, which is proposed medial density area from the PC 68, that is right against that horse arena.
Yes, I understand that. Yeah.
Yeah. I mean, you do not want to see so many people live in that area.
You're concerned that people will complain about dust or
yeah, they will. Yeah,
they'll start complaining. You say, well, I was here first. I mean, why should I have to be worried about that? That's your concern.
Yeah, yeah.
But of course, your concern wouldn't exist if your property is included in the change. Well, then you're obviously not concerned about this because that would then, this part of the land would be developed as well.
Yeah. So yeah, if everywhere to be subdivided, then basically this horse arena is going to be new property sometime, you know.
Yeah.
Then there's no huge issues. It's only a timing. So has I made the case clear?
Well, I've listened to what you had to say, and I'm grateful for it's a very helpful map and a very helpful aerial photograph. So helpful to show me where various features that you referred to are. Have you got, and I've listened to what you've got to say and I understand your position. Have you got anything else you want to add to that at all before we go on to the next witness or not?
Yeah, so as I mentioned, it's 4 options. So basically, I will be okay if the whole area to be new, the whole area will not be subdivided. Like a PC 68 will not go ahead. I will be okay with that. But if PC 68 is to be go ahead, then I would like my property to be rezoned as the same. Also, the neighbor's property, they are going to talk about their property, but I believe they will share the same opinion, same view. So if that's clear, then I have no more to say.
The primary position is everything's, all your concerns are met if you're part of the rezoning, but you've got a number of concerns that aren't met if you are not part of the rezoning, should that be approved.
Yep.
Yes, well, thank you very much for your presentation. You're free, of course, to listen to the rest of what's going on in this hearing. The position from now is we're going to hear some further witnesses now, and then we're having to adjourn for a while because a witness not available because of the COVID problem, and we're starting again on Monday. So it'll be some time after that my recommendation one way or the other will be made public. So thank you for your attendance.
Yeah, thank you, sir.
Thank you. I think we'll have a break now for a quarter of an hour. Thank you. And then we'll resume in 15 minutes. Thank you. Mr. Wakefield's submissions. Mr. Wakefield, good morning.
Good morning.
Just before we start, I just had a little bit of difficulty with the sound system before. If you just would make sure that you speak directly into the microphone just so that I can hear you. We'll just see how we get on. And we have now, or we've each now received a copy of your legal submission. Thank you. So if you'd like to start, thank you very much.
Fantastic. And look, we'll do the best at our end in terms of making sure that it's loud and clear. Hopefully you're hearing me okay now, but look, if you do...
Right. Thank you.
Excellent. All right. Well, sorry for that little blip earlier, sir. Glad to hear we're back on track. So you've got our legal submissions. Mr. Langman's filed evidence. I'll take you through the legal submissions, and based on listening into some of the hearing yesterday, it seemed to work fairly well if you had questions. So feel free to answer those as we go, if that's the best approach for yourself.
You were following the dialogue yesterday.
In places, I was able to sign on in the morning and listen to your conversation with Mr. Cleary, and again with Ms. Hart, but Mr. Langman was able to listen to the hearing in its fuller extent so that he was able to respond to some of the other merits issues that were discussed with yourself.
Thank you. Right, so if you just, perhaps just as with previously, if you want to depart from your written submissions, if you just tell me where you're departing, because I want to make a note, and I'd rather not make a note if it's already in here. You know what I mean?
Absolutely, understood. And look, there will be patches of these legal submissions where I don't think I need to take you through the submissions verbatim, sir, and I'll let you know about that when we get to that point. So starting off at 1.1, these submissions are made on behalf of the City Council and the Regional Council. City Council and Regional Council both submitted in opposition to PC 68, and they raise a number of common issues in those submissions. It's for that reason a joint case is presented with evidence presented by Mr. Langman, and you'll be familiar with that, sir. The CCC and Regional Council case raises two central concerns, being that the request does not qualify for consideration under the Responsive Planning Framework, which is under the NPSUD 2020, and that PC 68 is inconsistent with or contrary to a number of important policy directions in the regional policy statement. And to that extent, Mr. Langman's evidence does work its way through those provisions in the CRPS as well as the NPSUD. This request and others that have recently been heard by Selwyn District Council rely on largely the same interpretation of the NPSUD and CRPS. That is, that the avoidance direction in Part 6 of the CRPS, or Chapter 6, I should say, can be overcome by Policy 8 of the NPSUD. And in advancing this argument, the applicant has submitted that more weight should be given to the NPSUD and Policy 8 as the newest and higher ranking planning document. Although the councils acknowledge that the NPSUD is the higher order document, submitted that this is not a situation where the NPSUD should be interpreted as having this primacy or taking precedence over the RPS. Instead, it's submitted that the NPSUD and the regional policy statement can and should be read and applied together, with the CRPS allowed to adopt a policy approach that recognises and responds to its sub-regional context. If the applicant's interpretation was preferred and high demand in the Selwyn District demanded the approval of plan changes in reliance on Policy 8, in my submission, that would be failing to reconcile and apply the NPS as a whole, alongside the balance of the relevant statutory framework. It would also fail to accord with the relevant urban growth strategy established by the regional policy statement and which was recently updated by Change 1. Look, there have been some discussions, sir, about Change 1 already through this hearing, and I pick up on that point again in these submissions, so I'll revisit that with you.
I think I don't want to interrupt unduly, but the point which was of concern yesterday was whether when the Change 1 became operative in July 2021, that reflected a consideration of the national policy statement, and the suggestion being that it reacted to the earlier policy statement and not really the later one. So anyway, you'll no doubt address that, but that seemed to me to be, that's the point that is of concern.
Yes, aware of that, sir. At 1.7, allowing departures of this nature from existing strategic infrastructure and spatial planning decision-making is why the councils are taking this request and other plan changes seriously. Spatial planning is a core part of their respective statutory functions, and allowing continual greenfield urban expansion could ultimately undermine the intensification outcome that the Chapter 6 framework was originally devised to achieve. At 1.8, in summary, it's submitted that there is no sound legal interpretation that requires the responsive planning framework to be given greater weight or precedence over a CRPS framework that engages with fundamentally the same subject matter. The statutory requirement to give effect to the CRPS, which is relevant for the statutory decision to be made here, engages the avoid framework established by Chapter 6 of the RPS, with all lower order plan change decisions required to conform with that direction. And C, the outcome that the councils are supporting here is submitted to not be at odds with the intensification themes present in the NPSUD, CRPS, and now the Resource Management Enabling Housing Supply Act. If anything, the legislation and higher order policy documents collectively support limiting opportunities for speculative greenfield expansion in order to make better use of the available capacity within brownfield areas and achieve meaningful intensification and the benefits that can derive from that. So section 2, sir, just on that point, I know there's been some discussion as well about the effect of the enabling housing legislation, and you've had that discussion this morning with Ms. Limmer. I'm happy to have some discussion with you about that at the end of these submissions, to the extent that you might have those processing questions.
You're talking about the variation, etc., and how
That's
my role.
correct, yes.
Should we leave that till, I think probably rather than interruption now, we'll leave that till the end, shall we?
That seems sensible, yes.
Yeah. Please carry on.
Section 2, PC 68 and why it matters to these councils. Without traversing the details of the relief sought, the effect of rezoning would be to allow the living Z zoning to extend across land that is not identified for urban development on Map A of the Regional Policy Statement. As a result, the PC 68 proposal engages in conflicts with specific urban growth provisions contained in Chapter 6. Mr. Langman has addressed that in his evidence. He's also addressed the recent Change 1 amendments to Chapter 6 of the RPS, which I appreciate have been discussed between yourself, Ms. Hart, and others at this hearing already. You asked the question this morning or yesterday afternoon, sorry, around where this document exists, or if there is document available that you can review to understand what Change 1 was about and what was considered. In these submissions at 2.2, I've included a link to the relevant documentation, which is on the Environment Canterbury website.
I wonder whether, can I be frank, very often you go to a link in the sort of 300 pages. It would be very helpful, I think, if you were to make that available to me with noting on the side, perhaps with lines, etc., the particular parts that you're relying on. This is in relation to the particular matters which were taken into account when Map A was promulgated. Is that what you've been talking about?
No, this is really to identify for yourself, sir, that Change 1 did not ignore the NPSUD 2020. It was intentionally considered the role and effect of that NPS. And if you just turn the page on the submissions, paragraph 2.5, I've just noted there that the Regional Council was at all times live to the requirement to give effect to the NPSUD, and it noted as much in its report to the Minister. What I've also done to assist you there is I've included an appendix to these submissions, Appendix A, which you'll have with you, which is an excerpt from the Regional Council's report to the Minister in relation to Change 1. So if you were to turn to page 16 of these submissions,
Um,
So at page 16,
Sorry, just going back, if you want to rely on the online information, I think it would be helpful if you could perhaps make a copy available to me with just delineating the most important parts. I don't know how long it is. I mean, if it's 10 pages, it wouldn't matter, but I presume it's longer, and
look, I'm more than happy to do that, sir.
I think it'd be helpful if you wouldn't mind doing that. So can I just note that that'll be done?
Certainly. And look, I'll take you to the appendix in due course, but shall we proceed through these submissions first, and then we can revisit that point at the conclusion.
Thank you.
So continuing on at 2.3.
Yeah.
In summary, change 1 sought to build on existing strategic growth planning by the GCP and implement agreed actions contained in our space. In particular, it was intended to achieve the requirement in the NPS for local authorities to ensure that there was sufficient development capacity to meet expected demand for housing and business land over the medium and long term. Through change 1, several new future development areas, or FDAs, were identified, and associated new policy provisions were inserted to enable land within these areas to be rezoned by a Selwyn District Council or others if required to meet medium-term housing needs. Change 1 was supported by an evaluation completed by the Regional Council, which relevantly assessed the extent to which it would give effect to the NPSUD 2020 as well as the RMA. It is accepted that change 1 partially gave effect to the NPSUD, but it did not seek to give effect to all such requirements. And an example of that, sir, is of course the responsive criteria, which you'll be familiar with. The end result of the change 1 process was that the Minister agreed the changes would give effect to the NPSUD, and that's recorded in the Minister's decision as well. So the end result here, and this is at paragraph 2.4, is that there has been a recent change to the regional policy statement post the NPSUD 2020, which is specifically designed to provide requisite levels of development capacity across the temporal periods described in that national policy statement. And I've referenced there in 2.5 the excerpt from the Regional Council's report that it must give effect to both the NPSUD and the other NPS that was relevant. And at 2.6, there was specific discussion in the Regional Council's report which addressed the Chapter 6 and Map A framework and the NPSUD. Now, the context around this, sir, was that when change 1 was notified and sought to introduce these FDAs and associated provisions, there were submissions made which said that, in a nutshell, that's not enough. You need to do more than that. The NPSUD does require a more flexible approach to enabling development. So the excerpt that I've attached to the submissions, sir, is the Council's response to these submissions that sought improved or increased flexibility within change 1. And the Council records in a number of places there its concern that providing this innate or absolute flexibility could come at a cost to strategic planning, and indeed run risk that you'll see these ad hoc plan changes progressing, which will make it increasingly difficult for the councils and their strategic delivery of infrastructure to ensure that the overall outcome remains a well-functioning urban environment. So in those paragraphs, which are around about 12 in total, the council specifically considered those submissions and said, no, we're quite content to press on with change 1 as it's currently proposed. And through the development of the responsive planning criteria, that will be the point of time at which there'll be a more detailed response given to this responsive planning framework that exists in the NPSUD. So it wasn't that change 1 didn't engage with this matter at all. It specifically considered it, in the context of what the MPSUD was requiring.
I think the suggestion by the applicant as well, there was no reference to Prebbleton at all, no provision for growth in Prebbleton at all, which suggested that really no serious look at the Prebbleton situation had been undertaken. I think that's what the applicant's saying.
Yeah, that's right. And this isn't uncommon. This isn't unique to this particular proposal. What we are facing as submitters in opposition to these plan changes is landowners who are saying, we want this outcome in Prebbleton or West Melton or to the south of Lincoln, because that's in their best interest to seek these plan changes to rezone that land. But what the Regional Council and the Christchurch City Council are saying is that spatial planning exercises by their nature should be framed to consider the wider Greater Christchurch urban environment. That was the basis that the GCP worked up our space, which was tested through a local government decision-making process. The outcome in our space hasn't been subject to any judicial review. And so it was the our space outcome, which was then the subject of change 1, to bring across those recommendations around the future enabling of additional urban development, but not in a way that was completely enabling. It was still limited because the council had to bear in mind its own delivery of strategic infrastructure, roading, servicing, and all of those types of issues.
So you say the council was concerned about infrastructure?
Well, the council's concerned about a number of issues. And that comes through in Mr. Langman's evidence. This isn't just a case where the NPS, in our view and on our interpretation, requires innate flexibility in all cases. There is a strategic and an integrated element to this, which must form part of that evaluation. Can I continue?
Yes, please do.
At 2.7, so the Minister did not impugn the existing policy approach taken by the regional policy statement to the management of urban growth at a Greater Christchurch level. One such direction being to avoid unplanned expansion into surrounding rural areas. This remains a key part of the relevant statutory framework, and it is the risk of this aspect being overlooked or ignored which is of key concern to the councils. The applicant's evidence acknowledges that the proposal is inconsistent with the requirement to avoid urban development outside of MAP A, but states that this is not fatal to PC 68, as MAP A is now out of date. In reliance on the evidence of Mr. Langman and the above submissions, it's submitted that this planning opinion cannot reasonably be supported. Change 1 to the RPS amended MAP A to identify the FDAs in only July 2021, which can hardly be said to be outdated. And just on that point, sir, I think the suggestion that it was out of date is, I don't necessarily think it's trying to say that it was out of date in a time or length of time perspective. I understand that opinion to be expressed based on the economics evidence around what the numbers of what the demand figures look like now. So I just thought I'd just caveat that comment or clarify that comment. So section 3, the relevant statutory framework or statutory interpretation principles. We've reviewed the legal submissions that were presented yesterday, generally rely on the same description. Or at 3.2, there are relevant issues emerging from the higher order planning documents, which include the MPS and the regional policy statement. These issues have been identified in Mr. Langman's evidence and must be considered and evaluated as part of your decision-making exercise. And in order to assist, we highlight several additional matters. First is the layering and effect of...
I'm grateful for your that you will make the documents available to me relating to the background to the change which came into force in July of last year. So, well, those documents comprise that indicated in paragraph 2.2. There's some background there, isn't there?
Yes, that's right, sir.
And what about the, you're talking now about that, that the council was very much alive to the national, to this policy statement. What other documentary information can you make available to me?
Right, so to assist the...
Besides Appendix A, Appendix 1.
Yeah, certainly. So the report to the Minister for the Environment, I've included an excerpt from that in Appendix A, but it's probably going to be useful for us to provide that and indicate to you what the relevant sections will be. Attached to that report, there were 7 appendices in total. There was the proposed change text itself, which I don't think is necessarily relevant. There was a summary report of the written submissions, which again, I don't think is going to assist you with your exercise here. The Section 32 report will, I think, be useful. And then Appendix 5, which is a report which summarised the legal and statutory framework and considered the extent to which it complied with the relevant framework. And that's going to be useful because that demonstrates that the Regional Council considered how this change one would align with not just the CRPS, but also with the NPSUD and the other higher level planning documents.
Just pausing there, would it be possible for those documents to be made available to me a few days before next, we're on, what are we today, Tuesday, later in the week, this week, would that be possible?
Absolutely.
Because I think it would be helpful if I had a look at them prior to the last stage of this case on Monday, so that I'm sort of aware of what they consist of. Copies also should be made available to Mr. Cleary and any submitters that want them as well.
Well, I don't expect it will take our team very long to identify the relevant sections for you. So if we say provide this material to you and the hearings administrator electronically by close of play tomorrow, so that that can then be circulated to the applicant and the other submitters, would that be sensible? Yeah.
Yes, thank you. Just carry on. That's helpful.
Okay, so 3.3, the layering and effective planning documents. As recognised with the Supreme Court in King Salmon, the cascade of planning documents under the RMA are intended to give effect to Section 5 and Part 2 of the RMA. They do this by giving, and we've emphasised here, substance to its purpose by identifying objectives, policies, methods and rules with increasing particularity both as to substantive content and locality. And applying that cascade in this instance, it is accepted that the NPSUD provides high-level direction, but submitted that the CRPS provides more particularised regional and in particular sub-regional direction in relation to similar matters, as well as a number of other important policy issues. These other matters, and I've put there in brackets, for example, non-urban growth related matters, are needed to give effect to other NPSs and the other statutory requirements of Part 2 of the RMA. As a consequence, the CRPS is by nature a more wide-ranging policy document and must be read as a whole when assessing plan change requests of this nature. Section 75.3, which you'll be familiar with, requires that a district plan must give effect to any NPS and any regional policy statement. King Salmon has discussed that terminology ad nauseum. I won't read that excerpt there for you.
Thank you.
And at 3.7, Supreme Court went on to note that while the requirement to give effect is a strong directive, it is also context dependent. The court went on to note there, the implementation of such a directive will be affected by what it relates to, that is, what must be given effect to. Requirement to give effect to a policy which is framed in a specific and unqualified way may, in a practical sense, be more prescriptive than a requirement to give effect to a policy which is worded at a higher level of abstraction. In this instance, and as outlined in the planning evidence for the councils, there are a number of relevant policy directions in the NPSUD and the CRPS that vary in terms of their expression. This is relevant when seeking to reconcile planning documents with the nature and expression of the provisions being significant. 3.9. The applicant's submissions refer in passing to this doctrine but it's not clear whether they are submitting that it should be revoked in this instance or not. At 3.10, for completeness, submitted that this doctrine should not be invoked as the two provisions at issue, which are alleged to be in tension with each other, serve a different statutory function in our submission. To explain, Policy 8 of the NPSUD serves as an administrative pathway by opening the gate for plan changes and then allowing for them to be considered on their merits and against the relevant statutory framework. Whereas in clause B there, Objective 6.2.1 provides substantive policy direction in relation to the matter of urban growth in a sub-regional context, i.e. Greater Christchurch. As a result, submitted that the doctrine of implied repeal cannot and should not be invoked. It cannot be said that it is necessary for one to fall away in favour of the other, as the two can work in tandem. What is really at issue here is the end consequence for plan changes that are requested in the knowledge of their conflict with the regional policy statement. And we come to that below. So the next section says, touching on the relationship between the NPSUD and the regional policy statement. So without traversing the discussion in the applicant's submissions at length, the NPSUD contains a number of objectives and policies, all of which are intended to operate together. While the concept of delivering a well-functioning urban environment appears in multiple places, it's our submission that the NPS cannot be said to have one single overarching purpose. Instead, when read as a whole, it provides direction on a number of different components relating to urban development. And I'll just pause there, sir. The reason I've said urban development and isolated that specifically is that that's what this NPSUD is about. And in our submission, that serves to distinguish it from a document like the RPS, which by its nature is charged with assessing a multitude of other RMA matters beyond simply urban growth.
So the regional policy statement is wider, in other words, you're saying?
That's right, it is. It serves quite a different function. The NPS provides this direction on one issue, as NPSs do. You've got NPSs on freshwater, for example, being another example, and then also the coastal environment. They are focused on specific RM issues. They don't intend to capture the field in terms of the wide range of issues that the regional council is required to manage under Section 30, or indeed a district council is required to deal with under Section 31. So at 4.2, the responsive planning framework is one component of the NPSUD and is established by Objective 6 and Policy 8. As noted above, this framework, in our view, provides an administrative pathway for the consideration of out-of-sequence plan changes, subject to the satisfaction of certain criteria. These criteria include that the plan change would do those three things, which are referenced in Policy 8. And just on clause C, one of those criteria is, of course, that the plan change would meet the criteria set and included in a regional policy statement, which determine what plan changes will be treated as adding significantly to development capacity. I'm not sure if it's been touched on at all during this hearing so far, but I just thought I'd note that it is relevant that the criteria will be included in an RPS rather than in a district plan. And this is an issue which we've discussed with the panel that is currently tasked with hearing the Selwyn District Plan review process. They asked a question as to whether or not the criteria could, as a stopgap, be included in the district plan. And our response to that was no. For one, that's not what the NPS requires. And the reason behind that is that the criteria are intended to have a regional or sub-regional focus to them. By including them in the regional policy statement as well, it also means that they can't be sought for changes through district plan changes. It can only be a change to the RPS, which would be able to amend those criteria. And that, to a certain extent, protects them from any potential plan changes, which could do violence to the structure and approach taken. Now, 4.3. As Mr. Langman explains, the regional council.
There is an issue, I think, which obviously is relevant, being whether the regional council should have amended the policy statement, its policy statement, because of the national document. And I yesterday referred to section 55 of the RMA, where it stated that a local authority must amend a document if a national policy statement directs so. And the issue there was, well, was there any specific direction in the national policy statement, which meant that the regional council should amend its policy statement? What is your position about that?
Well, looking at the wording of section 55, it's section 55 subsection 2, which creates the mandatory requirement to amend a document. But that's caveated. It's where a national policy statement directs so to include specific objectives and policies set out in that statement, or so that the objectives and policies specified give effect to objectives and policies specified in the RPS, or sorry, in the NPS. 2D then states that in all cases, the local authority must make the amendments at 3 points in time. A, as soon as practical, or within the time limit specified in the NPS, if any, or C, before the occurrence of an event specified in the NPS. And I don't think any of those issues are captured clearly in section 55. For one thing, we're not talking about a direction in the NPS to include objectives and policies set out in that document. We're talking about the inclusion of criteria, which is different.
Yeah, just pausing there in relation to subsection 2B, the question is whether policy 8 means, in the national document, means that the regional council should amend its document. And that seems to me to depend upon whether you can find something in the national policy statement which actually directs that. There are two scenarios which are envisaged. The national policy statement may deal with a particular matter, but it may not direct that an amendment be made. And the question here is, well, what does this national policy statement, what's the position about this national policy statement? In other words, I'm asking you, do you say that it does not direct this?
It requires the inclusion and the development of criteria. I accept that. Policy 8 on its face doesn't direct any amendments. It simply relies on these criteria, which is to be included in the regional policy statement at some time. And then you go to the timing provision in the NPS, which is part 4, page 30.
Yes, it's the implementation one, is it?
That's right, timeframes for implementation. Yeah. There's no specific direction here in the timing section, which requires the regional council to respond to policy 8 by a specific date. And so therefore the amendments required are simply to be made as soon as practicable. So this is a relevant question, because I noted that it's been pitched as a failure on behalf of the regional council to not have included these criteria already. But in my submission, characterising it as a failure is not consistent with the expectations in the NPSUD. And I do address this issue in detail further below, but I note that our team and our firm has a close awareness of the development of these types of issues in response to the NPSUD. And to my knowledge, the only RPS at the moment which has notified these criteria to respond to Policy 8 is the Otago RPS, which was notified at the end of last year. The Auckland Council, for example, is still working through the development of the criteria with a view to notifying the change to its unitary plan in short order.
Well, I think that the question is whether in part 3, the implementation part, there was anything there which in terms of section 55.2 directs the amendment. And I think that Mr. Cleary would be relying on clause 3.7, talking about where there's insufficient development capacity, if it's wholly or partly a result of RMA planning documents, you've got to notify the minister and then change the documents in question. Have you got any comments about 3.7?
Not specifically. I see that as a different issue. The NPS does create a range of different obligations and requirements on local authorities, one of which is to constantly monitor demand, supply, and complete housing development capacity assessments at certain periods. And so as part of this monitoring requirement that the councils may well identify a shortfall or insufficiency in development capacity, and the NPS at that point is going to be triggered through clause 3.7. But that's a different issue from the development of criteria, which will guide when policy 8 and the responsive framework is engaged or not. I'm not aware, sir, at the moment as to whether the council has determined that there is any insufficiency across the short, medium or long term, which would warrant an immediate notification to the Minister for the Environment and then trigger any need to review the RPS or any of the lower order district plans. That's a matter of contest through some of these plan changes, of course, but it's not something I'm familiar that the councils have actioned of their own volition.
I don't understand the applicant to say that part of their case is that the regional council should have changed its plan. It's taken the stance that if you look at the national policy statement, you can, as you've said in your submissions, and I think there's clearly agreement. The question becomes whether or not this development should be allowed, and the regional policy statement ignored, having regard to particular policy 8. And I think Mr. Cleary yesterday made it clear, well, it's not just policy 8, you've got to read the whole document to find out what it all means. But so what the applicant is saying is, well, you don't need to, it doesn't matter that the policy statement hasn't been changed. I'm investigating that because I thought that there may or may not be a process. What your answer to that is, well, it takes a bit of time. No one except Dunedin has done that. And so that's taking time. And Mr. Cleary's point is, well, the national policy statement tries to leapfrog the delays which are, or to deal with the delays which are inherent in that process by enabling development to take place, et cetera, in terms of particular policy 8. But you don't agree. I understand your reasons for not agreeing with that.
Well, look, I'm not, we're not at a point of differing opinion in terms of the ability for an applicant to lodge a plan change in spite of an absence of criteria. That's accepted by the council, and it's actually acknowledged in the reports around change 1 that the absence of criteria is not going to stop plan changes potentially being requested, and they then need to be considered on their merits. We're merely highlighting for you here that this issue was raised yesterday, and we're providing some additional information for you around the role of these criteria when they are developed, and then there is a change to the RPS to include them. But we're not saying that the absence of it is a roadblock. And we're also not accepting that there is any infringement of Section 55 of the RMA, because I don't see that the NPS requirements are inconsistent with that provision. In fact, I think they recognise that provision and provide control to the regional council to determine when it is able to include these criteria in a way that is as soon as practicable.
The point you are making is that there will be no plan changes in the Canterbury regional area for involving, this is that whilst you can make a privately initiated plan change that can be made, none of them can be successful if they're seeking urbanisation and that land is outside the MAP A area.
Well, that's right, and that's where we.
No,
that's
no
where,
discretion. You're saying there's basically no discretion.
well, that's correct, and what we're saying is that there is. This is where the matter of interpretation becomes real, and the one that you're going to have to untangle and tackle. It's whether the NPS, properly interpreted, precludes this hard edge approach that the regional policy statement takes, or whether or not Policy 8 in the NPS requires that all regional and lower order plans must adopt a course of action which provides flexibility in all cases for additional urban development. And what the regional and city council is saying, that the relevant statutory framework is as it stands at the moment, post change 1. We do have MAP A, we do have an avoid framework in the RPS. And when you apply that relevant statutory framework, what that means is that a companion change should be sought to the regional policy statement alongside any district plan changes, so that the whole statutory framework moves in the same way to enable this additional urban development opportunity. And we touch on this later in the submission, so I wonder if I might just keep making progress and then we can revisit this. So I was at 4.3, sir. Noting that the Regional Council has not included these criteria yet in the RPS. As a consequence, PC68 needs to be considered against other potentially relevant factors, including those discussed in the non-binding guidance published by the Ministry, as well as the relevant objectives and policies concerning urban growth in the NPS and the CRPS. While the significant development capacity criterion is unique to the responsive planning framework, the other criteria set out in clause 3.82 engage with the requirement that urban environments are well functioning and well serviced. These criteria overlap with other NPSUD objectives and policies, including Objective 6, which indicates in our submission that although the responsive planning framework provides a pathway, it remains part of the wider coherent scheme of the NPSUD. And there are several reasons why the council support this interpretation. First, there is nothing expressly stated in the NPS that gives Policy 8 any elevated significance over any other objective or policy. To that extent, the councils do not accept that this component of the NPS should or could take primacy over any other aspect, or indeed over the RPS framework in relation to urban growth. Put another way, there is nothing in the NPS or Policy 8 that demands exceptions or legitimate departures from any other restrictive policy provisions. Second, the parent objective for Policy 8, which is Objective 6, puts 3 different matters on an equal footing, all of which have to be satisfied. The implication is that the responsive planning framework cannot be treated as a pathway isolated from the remainder of the NPSUD. And for that to be the case, it's submitted that this would need to be expressly stated. Instead, local authority decisions affecting urban environments are required in all cases to remain integrated with longer-term infrastructure decisions and to be strategic across the medium and long term, even when out-of-sequence proposals are being considered. Third, there is nothing stated expressly or implicitly in the NPS to suggest that the responsive planning framework provides, as enabling of, or directs innate flexibility for urban development, or that it amounts to a standalone substantive test for unanticipated development. Instead, it may be considered entirely appropriate as a means of achieving Objective 6 in a sub-regional context to develop and implement a restrictive framework that enables growth or provides for responsiveness in certain areas, but restricts growth in others. While the appropriateness of such a framework will depend on the facts and circumstances at hand, it's submitted that for Greater Christchurch, it could be found to be an entirely valid approach to give effect to the NPSUD. In addition, there's nothing in the NPS which precludes such an outcome which is what the applicant and other of the plan change requesters are contending. And E, finally, if precedence were given to being responsive on development capacity grounds alone, without engaging the other criteria, the end result would be a proliferation of ad hoc and potentially insignificant or speculative developments being granted. This could result in urban growth that is not properly integrated and inconsistent with existing growth strategies, which would be at odds with the NPS-UD in our submission when interpreted as a whole. Now, 4.6. The case for the applicant is that rigidly applying the avoidance direction in the RPS and preventing local authorities from acting in accordance with the NPS would be out of step with that document. The applicant says that avoiding sincere consideration of such a plan change on its merits would fundamentally go against the purpose of the NPS. In response, we observe that there's no provision or purpose statement in the NPS-UD that directs the enablement of development through plan changes. Instead, the NPS relies on the standard Schedule 1 process to evaluate and decide any plan changes, which engages all relevant RMA matters and the statutory framework. In addition, it's not our submission that any plan change request that conflicts with the RPS should not be considered. CCC and CRC accept that the processing of these plan changes appears at face value to be consistent with the intention of the responsive planning framework. However, neither Policy 8 nor the balance of that document give rise to any presumption of approval or support for any trumping of other statutory instruments. Instead, decision makers are required to consider requests against all aspects of the framework, the language used in the relevant provisions, and make a reasoned statutory decision. If the eventual recommendation is approval here, it will be in the knowledge that the district plan will end up non-compliant with the RPS. Now, the next section is considering the term responsive. In our submission, this term is important. It's a matter of contention between the parties. The applicant suggested that responsiveness demands that requests are considered on their merit and that they cannot be simply rejected because they are inconsistent with the statutory framework. This is a significant concern for the councils, that the responsive framework is being pitched as a positive or enabling mechanism for urgent urban growth when it is essentially devoid of any detailed substantive policy direction. If being responsive in terms of the NPS created an exception over the RPS in all cases, there is a real prospect of a failure to recognise and properly manage certain resource issues and depart in a material way from pre-existing strategic planning decisions. One example of this is with Objective 6.2.17, which directs the maintenance of character and amenity of rural areas and settlements. This aspect is not recognised in the NPS-UD, but remains a relevant RMA consideration for local authorities that are charged with managing the rural land resource. The applicant submitted that Policy 8 will be totally meaningless for Greater Christchurch if the RPS avoidance framework is respected. Now, in my submission, this only holds water if the term responsive is considered a proxy for a substantive direction to approve plan changes, but that is not what it says. It is possible to be responsive in other ways, including by collaborating with other local authorities and seeking to change the RPS, which will then provide the means of delivering the district plan change. It's submitted that there should be nothing confronting about suggesting that developers work with local authorities to investigate additional development opportunities. While it may not always achieve the immediate release of land, given the spatial planning matters at issue, this option is not unreasonable. Here, this is what the councils say should occur, through collaboration and a companion request to change the RPS, which is what the statutory framework requires until such time as the RPS is amended. On this point, the responsive planning framework criteria will, when introduced, play a critical role in evaluating plan change requests against Policy 8. These criteria have not yet been included, and that factor is of benefit to the applicant and the other requesters who have sought to take advantage of the lack of any context-driven criteria at this time. The reason we say this is that when the criteria are included, they will act to distinguish ad hoc and speculative plan changes from those that will actually deliver significant development capacity. These criteria must be context-driven and there is a real prospect that they could be expressed in firm, directive, or even hard-edged terms. The decision maker here is being tasked with preempting what those criteria will say and mean in both strategic planning terms and on the merits, which is unfortunate timing. However, and as we've just discussed, there's no failure on behalf of the Regional Council here, as there was no date stated by which the criteria had to be included. And there are important strategic aspects to the criteria which warrant close and careful attention, as well as collaboration between the relevant GCP members. Finally, and again in response to the suggestion that the Council's interpretation renders Policy 8 meaningless, we do note that the FDAs brought in by Change 1 provide for flexibility and responsiveness in areas that are not currently live zoned in district plans for urbanisation. Outside of those areas, there is of course a restriction on urban development, but within the FDAs, there is an ability to be responsive. And I note, sir, that those opportunities are being taken up in other plan change requests and also through submissions on the cell and district plan review. Now, the next section briefly touches on the merits, and I merely note in paras 5.1 and 5.2 that Mr. Langman has identified the Council's concerns in his evidence, and that he's not satisfied that PC68 will satisfy the criteria for the responsive planning framework as a whole. And just for completeness, in paragraph 5.4, I noted yesterday that Mr. Cleary, perhaps by mistake, noted orally that Mr. Langman had accepted that PC68 would provide significant development capacity. But just to clarify, his evidence accepts that in terms of the quantum, i.e. the numbers of dwellings provided, but not when that particular aspect is considered more in the round against the wider context. Section 6, sir, precedent and cumulative effects. If the primary relief sought is approved, it's submitted that this could create a significant and important legal and potential planning precedent. From a planning perspective, there is Environment Court authority that the issue of cumulative effects is better addressed or considered in terms of whether a plan change would implement policies and objectives rather than the merits of a plan change. And here there's a live question as to whether there are constraints associated which conflict or cause tension with policies in the regional policy statement. And it's in that context that Mr. Langman's raised cumulative effects as a concern. From a legal perspective, there are other plan change requests in train that engage the same NPS and RPS tension. There's clearly appetite for residential development outside the areas anticipated by MAP-A. And while each plan change request will turn on its merits, if the relevant planning provisions are interpreted and applied in a manner that disregards the RPS and its avoid framework, this could develop into a legal precedent, as there would be no principled basis to resist further proposals in Selwyn or potentially other districts. 2 further sections to go, sir. 7, the scope for other submitters to rezone adjacent land. Now, the applicants indicated that they're neutral to those other submissions. And in 7.2, for the same reasons outlined in these submissions and Mr. Langman's evidence, the Council submit that these submissions should be rejected on the same basis. I did listen into your conversation this morning with Ms. Limmer, sir, and quite obviously an at-length discussion around what is on a plan change and motor machinists in Clearwater and Albany North, for example, and I understand that those authorities will be sent to you. One observation which I thought I would make to you is your comment on the second limb of the Clearwater test, which is that focused on the natural justice or potential prejudice or fairness issues that arise when considering scope. The second limb is directed at whether there's a real risk that persons have been denied an effective response to relief sought through a submission. And just one comment and observation for you is that the submission by Mr. Shami in this case did start with primary relief, which opposed PC68 in its entirety. That was clearly stated in that submission as the preferred option. And it's only in that original submission, the less preferred outcome was to rezone the land conditional on PC68 being approved. So what we have now is a position where Mr. Shami, as I understand it, is now supporting PC68 and the grant of the rezoning, which as a consequence means that his
Sorry,
land can come into the fold.
Yeah, to speak more clearly into it. So you're noting the discussion that I had with Ms. Limmer this morning.
That's
and
right.
Suggestion that to cure the problem, this land should be incorporated into the plan change. Right.
What I was really saying.
I missed the point. What's your response to that?
What I was saying, sir, is picking up on the second limb of the Clearwater test, which is concerned with whether persons have missed out on an effective opportunity to respond.
Yeah.
And it was helpful to go back to the original submission that was made, which expresses two views on PC 68. The first is primary relief, which opposes the rezoning. And the second is characterised as a less preferred alternative, which is to also rezone the submitter's land. So the submitter has put a submission in which states a preferred option. And I'm just making the observation that there is the potential that persons might have read that submission and thought, well, we don't need to be involved because the preferred option is to oppose. I'm not making any further submissions on that point. I just thought I'd raise that for you so that you're aware of it as part of that scope consideration.
But one of the things that was exercising my mind when I was asking those questions to Ms. Limmer this morning was, if, as is the case, each of the submitters are giving evidence to me, before me, on their present position, and if I am satisfied that they now at least know of the full position, and that position is that they support the rezoning, then wouldn't that mean that, as far as the second leg is concerned of that test, would I be justified in saying, well, I don't need to have concerns about that because they're all here and they're saying what they want now, notwithstanding what they may have put in their submission, in other words?
If you are satisfied that all potentially affected persons were live to the issue and the relief sought, then yes.
With the second leg would be satisfied if they all each said, yes, we now agree. Our position is that we want our land rezoned, because of course what the second leg is concerned about is someone coming along later on and saying, well, hang on, if I'd known about this, I would have taken some steps. And if there's logically no one else that can take a step, I suppose you could say the people on the other side of the road or whatever, I don't know, that's a matter I'll have to look in, obviously, but if at least amongst those 4 property owners, the 3 plus Mr. Shammy, that they wanted rezoning, if I decided to make a recommendation that the land should be rezoned, then they want rezoning, well then it seemed to me arguable anyway that the second leg is satisfied.
Yes, but I do think the second leg is also tackling the broader issue around whether there are any natural justice or fairness issues arising from granting any incidental or consequential relief. And so while in this case you've got Mr. Shami and the others who have made submissions, I'm not sure to the extent that captures the field in terms of potentially affected persons. And I don't think I can help you any more on that issue.
No, what you're saying is that just having them in agreement is not enough, because I've got to be satisfied on a merit analysis that there would have been no change to the position. In other words, if someone would come along and said, well, look, there are merit-based matters that I want to raise that I haven't raised because of the particular procedure which was followed.
Look, I think that's quite right. That's the mischief which the legal test is designed to avoid. It's trying to avoid issues slipping through the cracks. when they would normally have been expected to have been picked up through the assessment supporting the plan change.
Just give me a second, would you?
Certainly.
Right, thank you. Just carry on. So the conclusion, I think we're up to now, are we?
That's right, sir. So the Commissioner is obliged to assess this request against the relevant statutory tests. We've been through section 75. 8.2, second sentence, the statutory exercise, when correctly applied and undertaken, will not involve a contest between the two documents or giving preference to one over the other. Chapter 6 provides a relevant, tested and directive urban growth strategy that aligns with existing strategic planning decisions at a sub-regional level. It also responds to the multitude of RMA issues relevant to urban growth within Greater Christchurch, including the recent our space work by the Greater Christchurch Partnership, that should say. Giving effect to Chapter 6 of the RPS demands that PC 68 cannot be granted. There is no flexibility to decide otherwise without failing to give effect to the RPS. It's submitted that this outcome would be entirely consistent with an interpretation of the MPS as a whole, in accordance with well-established legal principles. While this applicant is taking the opportunity to argue that the RPS framework must be softened because of the MPSUD, these arguments have been made by developers who know that they cannot satisfy the RPS avoid framework. In any case, the applicant has elected to take on this challenge and ultimately bears that risk. There's clearly an easier option and an available option, I should say, for these developers to advance changes to the lower ordered district plan instead of facing up to the RPS at the outset. This bottom-up planning approach runs counter to the hierarchy of planning documents under the RMA and is not supported by any express direction in the NPS that other aspects of the statutory framework can be superseded in this way. While the plan change process has been a feature of the RMA since its inception, the process to change a regional policy statement in section 60 of the RMA is also well known and cannot simply be ignored. In terms of options, it's submitted that a contingent approval of PC 68 pending resolution of a later consequential change to the RPS is neither legally available nor would it be appropriate. Adopting that approach would involve making an approval in this case that is meaningless until a separate statutory decision is made by the Regional Council, with no certainty that PC 68 could ever be implemented. It would also create a significant degree of uncertainty and confusion in that it would create a perception that development is appropriate for PC 68 in circumstances where that development relies on a separate statutory process. It would result in unnecessary and undesirable uncertainty. It would fail to satisfy section 75.3, and it could be taken as support for a legal interpretation that in our submission elevates a procedural or administrative pathway into a merits test and in a manner which prevails over a clear and directive approach to strategic urban growth and infrastructure for Greater Christchurch. The only other option available would be to recommend to Selwyn District Council that it request a change to the RPS, which would then trigger a section 60 RMA change process. But as noted, that will not provide any substantive outcome because it relies on a separate decision by the Regional Council and also Selwyn District Council that's not within the scope of Clause 10. So those are my submissions, sir. And as we mentioned earlier, Appendix A just attaches an excerpt from the Change 1 report. And we'll make available the other documentation to you tomorrow, which identifies the parts which we say are of most relevance. The other issue which we were going to revisit.
Corey, just on that topic about making things available to me, would you be kind enough also to make available to me the cases that, I think there's one particular case you referred to that I wasn't familiar with, footnote 21, the Canterbury Fields case.
Certainly.
Be that available to me as well. Are there any others? Oh, there's King Salmon, which of course I think well, I don't really want that.
I suspect you might receive a number of cases following these submissions, sir. By the sounds of the scope discussion this morning, you'll be receiving the 140-page Albany North decision as well.
So
I suspect, would it be most convenient if I liaise with Mr. Cleary so that he just provides one bundle of authorities to you rather than you receiving them from different council?
That's what I'm suggesting.
just one, you mentioned the process for changing a regional policy statement. Just refresh my memory, does that involve the constituent members, i.e. local authorities, making the request to the regional council?
That's right. So the process itself is the same Schedule 1 process, which is being followed in this case. But Section 60 states that an RPS may be changed using Schedule 1, but at the instigation of a Minister of the Crown, the Regional Council, or any territorial authority within or partly within the relevant region. So what that does is it limits the ability to change an RPS to either the Crown, Minister, or the regional or district councils. And so that's why we say that if a developer or plan change requester is keen to see a change to the district plan that conflicts with the RPS, then the best approach is to liaise and engage with the relevant councils so that the request can be accompanied by a companion change to the RPS, which collectively will allow the district plan to be amended in a way that doesn't do violence to Section 75(3).
Process available to the applicant so that it can advance that alongside saying, well, I want to change the RPS and I want approval of this plan change. It's not, that doesn't work that way, does it?
No, the applicant needs to work in tandem with the relevant district council.
Yeah.
And we say that's what is contemplated by the NPS as well. If you were able to look at policy 10 of the NPSUD, sir.
What was that section? I missed the section number you mentioned.
Section 60 of the RMA is the one that governs RPS changes. But if you were able to turn to the NPSUD in policy 10.
Now,
I just wanted to raise this policy with you. I'm not sure if it's been brought to your attention yet.
Just pause for a second, would you? You mentioned at the conclusion of your submissions, you mentioned the only other option available would be to recommend to the Selwyn District Council that it request a change. That's not, I can't see that that's within my jurisdiction to make that recommendation. I'm being asked to make a recommendation on a private plan change. Where would I have jurisdiction to make that?
Well, look, you are tasked with making a statutory decision in terms of Schedule 1, so I accept that the jurisdiction might be limited in that respect. There have been other instances where we've seen panel recommendations that raise the prospect of other forms of statutory process, whether it be land use planning studies and the like. But what we've made, the observation we make in that paragraph is that even if a recommendation was made along those lines, the council would then be required to make a decision on whether to uptake that recommendation. And if it did and sought a change to the RPS, that would also be contingent on a regional council decision following a Schedule 1 process. So there's a lot of uncertainty there as well, which really doesn't leave us any further down the path.
Can I just, the applicant's case centres around the proposition that the relevant policy statement, the national policy statement, is a reaction to what the government sees as a housing crisis, and that it provides a machinery for getting going, ignoring planning instruments such as the regional policy statement and getting on with things. Now, isn't the point that the process which you're saying has to be undertaken, namely a change to the regional policy statement, is really going to take, I mean, there are clearly significant time delays in relation to that process. That may or may not impact upon whether your interpretation of the relationship between the national policy statement and the regional policy statement is correct or not. But what do you say of the underlying thrust of the national policy statement, which is that we've got to get on with urbanisation as a crisis, in terms of the timing issues I've just raised?
Well, there's no reference to urgency in the NPSUD at all. There's also no specific objective or policy which talks about enabling urban development in the way that's being promoted by the plan change requesters. What does come through in our interpretation here is that the NPS is still focused on achieving or making decisions on urban development that are integrated, strategic and responsive. Now, if you have the NPS open in front of you, Objective 6 quite clearly brings all three of those matters into the fold, which suggests that spatial planning is not out the window.
Well,
strategic integrated decision making is still relevant. Now, if you then turn to policy 10, and this was the one I tried to take you to earlier, policy 10 notes there that Tier 1 local authorities, which is the case here, that share jurisdiction are going to work together when implementing this national policy statement. They are to engage with providers of development infrastructure and additional infrastructure to achieve integrated land use and infrastructure planning. So that's the strategic decision-making element. And then C, engage with the development sector to identify significant opportunities for urban development. So this is where the collaboration point that I was making comes into the fore. It says here that this NPS wants all of these things to happen. It wants these discussions to take place so that you're putting development in the right place with a view to achieving well-functioning urban environments. It's not saying, in our interpretation, open up the gates for development, come what may, because that's going to be delivering an outcome that is potentially problematic. And so that the urgency, yes, we accept that this is a part of the government's urban growth response to this demand and supply issue. But the NPS itself, in our view, doesn't do away entirely with considered approaches to the location of additional development capacity.
So are you saying that, and I want to make this, I just need to clarify this, that the national policy statement on urban development has a discussion paper which preceded a planning for successful cities, and Mr. Cleary has submitted that parts of that particular document are relevant in relation to the interpretation of the national policy statement. Now, isn't the basis of that earlier document, that's to say the planning for successful cities, that there is a problem with housing at the moment, or do you say that that's simply not referred to in that document?
This is part of the problem, I think, with the extrinsic material and even the non-binding guidance from the ministry. There are a lot of interesting comments in there which don't necessarily reflect the expression of language in the NPSUD. What we're saying to you is that this policy document needs to be interpreted on its face value, and we're not reading the same messaging that comes through in the NPSUD versus what was discussed at that previous level. We accept that this is part of the government's response to housing supply and affordability issues. And there are a number of objectives and policies in this document which do require the regional and local authorities to respond to these issues through various measures. But the suggestion that it's an enabling tool for urban and greenfield expansion is something that these councils particularly struggle with. when it could similarly be suggested that enabling or pushing intensification is an outcome, wanting to see development within your existing brownfield areas rather than progressive expansion into the greenfield. And then, of course, you've got the enabling housing supply legislation as well, which we haven't talked about yet, which is again looking at further enabling intensification opportunities within existing residential zones.
So your position is basically that the regional policy statement, MAP A, does provide for sufficient opportunities for urbanisation.
Well, what we're saying is that that is an appropriate response at a sub-regional level.
Yes, but you're saying it is an appropriate response, aren't you? You say that there has been an appropriate response at a sub-regional level, which is reflected in MAP A.
Well, that's correct, yes. And the issue again, sir, is that this argument which we're facing arises because of the particular context applying to Greater Christchurch. We're familiar with other regional policy statements around New Zealand which don't have this hard edge sitting in the regional policy statement. There are district plans, I should say, that have the hard edge and an avoid framework around urban growth. But because they're in the district plan, that can be the subject of plan changes by the likes of the applicant. The consequence here is that the RPS is not able to be changed by those applicants, which creates this tension that you're having to tackle with.
Can we just deal with the variation issue now? You heard the discussion yesterday, or I think you're aware of it anyway, on the footing that, of my understanding, that the variation report of the Selwyn District Council indicates that if I were to recommend approval of this plan change, the council would then consider my decision and then either accept my recommendation or not accept it, but would not go as far as approving the change under clause 17 on the basis that this change would then, if recommended and accepted by the council, find its way into the variation, and which would then be subject to a further public notification. And my comment yesterday was that I didn't think that that was anything to do with me. I've got to deal with this particular change and make a recommendation, and that's my task. But it did seem that the submitters and all parties would have another, if I put a bite of the cherry, when the variation is promulgated. Have you got any comments to make about that procedure?
Look, I'm inclined to agree with your observation made this morning that it's not really your concern. Your duty is to consider this request and make a recommendation to the council, and then what the council does with that after the fact,
not for me.
It's not for you to be concerned with. But I have seen the report and the advice from Selwyn District Council on what might happen to this plan change if it is recommended for approval. And I'm not on all fours with the Selwyn position on that front. They're suggesting that if the recommendation is to approve PC 68, it would be merged into the Selwyn variation on the PDP. But I don't think that is correct, because there is a clause in Part 12 of Schedule 1 to the Act which says that the variation to a plan change does not merge with the specified territorial authority's IPI, but is processed at the same time using the ISPP, which is the Intensification Streamlined Planning Process. The consequence of this means that if you do make a decision to recommend, and the council were to accept that, but not make it operative, then it would remain a proposed plan. It would then need to be varied using the normal Schedule 1 process, but that would be happening through the ISPP. So Other people would have the opportunity to make submissions in the normal way. But because it's using the ISPP, there are no resulting appeal rights following the end of decisions through that process.
So I'm just losing you there. The appeal rights, so you say that there are no appeal rights in relation to what?
Decisions made through an ISPP process.
Oh, I see.
So the discussion you had yesterday is correct. There'll be a second go, I suppose, at this plan change, but it won't be on the same basis. It will be on the basis that PC 68 incorporates the medium density residential standards, which the Enabling Act requires. So the merits of it will be different.
Effectively absorbed into that variation which deals with that, the Enabling Act requirements, it loses the appeal rights are lost because of that.
Correct.
Yeah, I understand. As I say,
so what's interesting is that
my position is that it's not for me to concern myself with that, and I remain of the view that my duty is to make a decision about this particular plan change and make a recommendation, and then what happens to that is not a matter for me.
Consider yourself lucky in that respect, sir. I suspect it's a fairly complex piece of legislation, so maybe it's best that you focus on your task.
Well, I'm aware of one other plan change where Mr. Corwell, an independent commissioner, has made a recommendation which I understand was accepted by the council, but that was in relation to West Melton, I think. So I think that has been approved by the council, as I understand it.
Correct.
All right. Well, thank you very much. So you'll make those documents available to me, will you? Or,
yes.
Thank you. And if necessary, liaise with Mr. Cleary. I suggest you liaise with him so we can have a rather seamless sort of transition of.
Very happy to.
Yeah, thank you. Thank you for that. Just have a short break before I start the next witness. Thank you.
I don't want to speak out of turn, but I noticed, I think Ms. Limmer's not here. She didn't remain. The regional council, my understanding, didn't respond. Actually, lodged this.
She's what?
Ms. Limmer's not here. The regional council, the city council, didn't lodge a further submission on Mr. Shane's submission. And so I think Ms. Limmer might have been a bit surprised if she had been here, if my primary friend making some comments on her submission. I wonder whether it would be appropriate for Ms. Limmer to be given some opportunity to respond.
Yes. In relation to the change.
Just in relation to my Mr. Wakefield's comments on the Shaney submission, the Shaney position.
Yes. I'll consider that. I think that's right. I'll consider that, and I'll end of that. I'll just make a note of it now. Right. Mr. Langman, up to you.
Thank you, Mr. Chair. Possibly if I start at paragraph 4 of my evidence, essentially.
Really, the sound system is simply not good enough. I can't hear properly. I'm struggling just on that one. Is there some way you could speak more into the speaker more clearly or not?
How is that for volume? Better?
I think. Can you all hear at the back? Okay. Right, that's fine. So you've got a summary of your evidence at the beginning, haven't you?
Yes, I do, from paragraph 4.
Is that what you're proposing to read at this stage? Or
yes, it is. Yes. Yes. So I've had the opportunity to visit the site and look around the immediate area. Just one of the things that I noted on the in listening to the discussion yesterday was in relation to Kingcraft Place, opposite the plan change area. In the proposed district plan, that particular area isn't a large lot residential zone. It's actually
there.
Certainly.
Trying to adjust the mic as well.
I really am struggling with this. Is
it up for volume?
Are you able to? Yes, it's the microphone not quite the right.
Try that.
That's better.
Try to talk now.
Just talk now to see if that's better.
Certainly, I'll see if I can increase my input volume. Is that a little bit better?
Yeah, this is better. It would be a gross understatement. I can actually hear what you're saying. Thank you very much. That really is going to help. Right, that's far better. So we now, without having to strain, we'll be able to hear. So you're going to read the summary and just carry on beyond that point, however you like.
Yeah, sorry, did you hear my previous comment about Kingcraft Place? So I've had the opportunity to visit the site and the surrounding area. And I just note that in relation to Kingcraft Place, which I think was referred to as a rural residential area yesterday, and it certainly has that character. That particular area is proposed to be a general rural zone in the proposed district plan. So I think that's just a relevant point to note, that it doesn't comprise part of the urban area in the PDP. So I've reviewed the Plan Change 68 request and supporting evidence and material, and also had the opportunity to listen to the submitters' discussions yesterday. The Plan Change applicants' discussion yesterday, and the legal submissions of Mr. Cleary as well. Just in summary, in my opinion, the relief sought should be declined. While I accept that Plan Change 68 could be considered to add significant capacity for housing in the local context in terms of a quantum of dwellings, and I know that I'm quite careful with my language there, as Mr. Wakefield pointed out, that I don't accept that the proposal provides significant development capacity as set out in the MPSUD. The relevant urban environment context in which significant development capacity
Pull it back a wee bit, I think it's moving.
Should be considered as Greater Christchurch. As Mr. Wakefield noted, no criteria have yet been set out by the Regional Council for determining or guiding what is significant additional development capacity. And that, in particular, sets out the need to provide for a well-functioning urban environment in accordance with Policy 1. Sufficient development capacity has already been identified to meet expecting housing demands over the medium term for the Greater Christchurch urban environment, including Selwyn District. And the proposed housing typologies do not go far enough to align with the housing needs that are identified in the 2021 Housing Capacity Assessment. The cumulative impact of this and other unplanned and anticipated greenfield expansion would likely compromise opportunity for intensification elsewhere in Greater Christchurch. And that's really a function of the opportunity to buy greenfield land as opposed to buying land that is developed via intensification. And the impact on servicing ability in terms of in particular areas that are already planned for development as well. So that's the FDAs and the GPAs. The government's targeted intensification of existing urban areas by requiring that Tier 1 local authorities incorporate the NDRS provisions into their plans. And one of the reasons for doing so is to more productively and efficiently use urban land and reduce pressure for urban expansion on sprawl into greenfield areas, including onto highly productive land, which is impacted by this particular plan change. In my view, PC 68 runs counter to that intention. No evidence has been filed by the Plan Change 68 applicant, which addresses whether any qualifying matters exist for the plan change land that would warrant modifying the NDRS. So that would mean not including higher densities or provision for higher densities. And as a result, there's the potential for further downstream impacts if this land is rezoned and then later intensified through the NDRS provisions. In my view, this warrants close and careful consideration of constraints and a precautionary approach due to potential effects. The request is out of sequence with planned infrastructure development as depicted through the CRPS, and that's in terms of the projected infrastructure boundaries. And the implications of the NDRS in terms of infrastructure development have not been taken into account. In my view, it wouldn't contribute to a well-functioning urban environment that is well connected along transport corridors. And PC 68 does not give effect to the following provisions which I set out in relation to the regional policy statement, and I know that you've traversed that with the witnesses and legal counsel. Probably just focusing on policy 634, the wording is quite certain, and it says to ensure that new urban activities only occur within existing urban areas or identified greenfield priority areas as shown on map A unless otherwise expressly provided for. And the CRPS does provide for development within future development areas. In my view, and that leads to also just a point that the plan change itself isn't the most appropriate to achieve the objectives in the Selwyn District Plan. And that becomes quite critical in terms of a Section 32 evaluation, because that's the test that applies to whether you consider the proposal should be approved or not. The plan change applicant had the opportunity to look to vary those provisions, but they've not done so. And the plan change evidence does not properly attempt to reconcile, in my view, the statutory requirement to give effect to both the CRPS and the MPSUD, and you've traversed that particular issue with Mr. Wakefield. And throughout the evidence, Ms. Hart refers to an incorrect test when concluding that the proposed zoning is not inconsistent with 6.3.1, whereas the correct test does not give effect to. In my opinion, the CRPS and the MPSUD provisions can and should be read together. And there's nothing in the MPSUD that, in my view, can be interpreted as taking precedence over the provisions of the CRPS. In my view, taking into account the higher order planning documents and the provisions of Section 32 of the RMA, I consider the most appropriate room for the balance of this land is to remain rural plains. In reaching my conclusions, I outline why I consider the CRPS as not inconsistent or in conflict with the MPSUD. And I know that I've previously presented the same position in relation to a number of plan changes in Selwyn District, including PC 69 and 72 and 71, each in Rolleston, Lincoln and Prebbleton.
Just pausing there, talking about the other plan changes. I'm aware of Commissioner Corwell's decision in relation to a West Melton development.
Yes.
How many others are there, to your knowledge, that deal with, that are outside Map A, so to speak, and are being considered or have about to be considered?
So I think this is the last of the plan changes. I think at this stage that have been notified. That's correct. But I do outline in my evidence the range of plan changes. I think it's at paragraph 86 of my evidence, I outline the full range of plan changes. Just noting that plan change at West Melton is now approved. So I think there's.
That's been approved, I think, hasn't it?
Yes.
And that's had a clause 17 approval too, has it?
I believe so. I believe there's approximately 18 plan changes. So on the and just probably relevant to that question as well, that those plan changes represent an increase of around 11,500 households based on the Living Z provisions and the various provisions that are sought specific to those plan changes. Of course, that's probably an underestimate, given that a number will be subject to the IPI process. And new medium density residential standards.
You heard my questioning this morning of Mr. Wakefield about the question of whether or not the National Policy Statement for Urban Development was a response to a housing crisis, so to speak. And I think his response was, well, there's nothing in that statement, or indeed the precursor to the statement, which indicated that. Do you agree with that, or are you able to comment on that?
I haven't looked particularly at that particular search for the word crisis, but the NPSUD and the RM Amendment Act both were to look to essentially unlock supply in terms of housing. Yes.
Right.
And I think the point is that that's a nationwide issue. It's not something that's particular to Christchurch. The capacity figures that are referred to in the 2021 housing capacity assessment show that there's a surplus, or that demand in the short to medium term is being met. There's a shortfall in the longer term. And I would expect that particular issue is addressed either both through the NDSR provisions applying across Greater Christchurch, or potentially through additional areas being included within the regional policy statement when it's reviewed. I think possibly just to pick up on that, you did briefly discuss the point that this morning with Mr. Wakefield that applicants do not have an opportunity to change a regional policy statement, and that's correct in terms of a private plan change. There is the opportunity obviously to submit on the regional policy statement on its review in 2024. It's currently planned for 2024.
So the pathway, if one accepts that the relevant policies in the regional policy statement prevent this going ahead, the only pathway is for the local authorities or a local authority to request a change to the regional policy statement. That's
prior to 2024 when there's a general review being planned. That's correct. So one possible pathway, and I think I've outlined it in my evidence, is that at the same time that a plan change is notified on a district plan, both the regional council and the district councils working in tandem potentially hear both a change to the RPS, if the district council had sought a change to the RPS, hear a change to the RPS and a district plan change at the same time. That hasn't occurred.
So at the moment, as my understanding is, that there's no council that's requested a change to the RPS as a result of this policy statement.
No.
And I think that my further understanding about that is that from Mr. Wakefield was, well, part of the reason is that the process of examining what needs to be changed, etc., takes some time.
Yes.
Or we're only partway through that time. Do you agree with that or not?
That's correct. That's correct. Yeah.
Just pause there, would you?
The other possibility is the application of the criteria to reduce significant development capacity. My understanding, and I've discussed this with the regional councils, that process is underway in terms of developing criteria. There are potentially a number of factors that might influence the outcome of that. Firstly, one is obviously a hearing process, which will be open to submissions. And that will also assist with determining what constitutes a well-functioning environment. And I just note that in terms of policy one, it's expressed in a manner that the matters addressed in policy one are a minimum consideration for what constitutes a well-functioning urban environment. So potentially another complicating factor is a national policy statement on highly productive land. We don't know necessarily what the content of that is. We have a draft of it. That could also potentially influence what determines a well-functioning urban environment in terms of expansion into highly productive land. At this stage, I can't say with any certainty as to what those criteria will look like, but that's difficult to determine at this stage.
I think one of the issues was the extent to which the Enabling Act, providing for the 3-storey dwellings, etc., rather more intensive development, was going to make any difference to this particular change. And the evidence we heard from the applicant was, well, it was unlikely to, because the housing stock was relatively young, and it's unlikely that people are going to pull down relatively new houses to facilitate 3-story houses, etc., or greater intensification. And secondly, there aren't any sections available. Do you agree with that or not?
That's possibly correct for Selwyn District, and Mr. Colgrave has included a table in his evidence around the relative age of housing, which is helpful in sort of quantifying in that respect. How that relates to newly rezoned development is probably a different question. So existing vacant land and what the uptake within the existing vacant land is. And that's going to depend on the sort of highest and best use of that land and the marketability of development within those greenfield areas. And there are a number of examples around Christchurch. I think if you're familiar with Beach Grove out in Waimakariri, Silverstream, which includes high density development, let's call it medium density development, which has been popular in terms of its uptake. So I don't necessarily agree that that type of development is unlikely to be taken up. Those development opportunities are unlikely to be taken up. Highfield is another example where that's also taking place. And I think particularly in terms of the character of Prebbleton, I don't know if I think it's a Somerset Village's retirement home or retirement village that's currently being constructed within Prebbleton. Again, that's another example of the type of high density use and provision of housing which people will elect to move to if those opportunities arise.
Yes, thank you. It's certainly I may say so, a fairly difficult position in the absence of any statutory direction really on this issue. I mean, the critical issue of the relationship between the regional policy statement and the national policy statement on urban development. It's in the absence of any guidance, statutory guidance. It is a very it's a complex and difficult issue.
It is.
And obviously I'm going to do the best I can to resolve it at this stage, and I'll do so. But those comments are very helpful. Are there any other comments you want to make in relation to the main body of your evidence or not?
Not in relation to the main body of my evidence. If you have any questions.
There's a fundamental difference between the approach taken by Ms. Hart and your approach. And I've got to try and resolve that difference, obviously, as best I can. But it essentially revolves around a legal analysis rather than a merit-based one in the first instance to see whether or not the matters which you're raising are, in fact, a barrier to proceeding any further.
Yes, that's correct. But I think on the merits basis, I think one of the things that I'll probably point out in relation to this particular plan change is that while the key, there's a couple of key aspects really that are probably worth highlighting. One is the issue of greenhouse gas emissions and demonstrating that it will support a reduction in greenhouse gas emissions has been very lightly brushed over. The second is that the proposal will be well connected along transport corridors. And whilst the applicant said that the proposal can cater for buses, at the moment the existing bus route goes from Lincoln down Birches Road before hitting Springs Road. And so that travels to the centre of Prebbleton. And we've also got the complicating factor of 2 other plan changes in the south of Prebbleton, which will also increase similar public transport requirements. So I think for a significant amount of time, given that there's no employment opportunities provided with this plan change, and that differs from the future development areas that were identified at Rolleston, all travel is essentially going to be by private motor car. That makes it difficult to justify a reduction in greenhouse gas emissions. And just one thing that I probably note, and I pointed out in my evidence, but the development at West Melton that was recommended for approval by Mr. Corwell included a requirement for solar electricity generation, minimum requirements for Indigenous planting. And so those 2 factors, if you are going to take a qualitative approach to the greenhouse gas emission issue, at least that demonstrated it was contributing to a reduction in greenhouse gas emissions, as opposed to perhaps what might be provided for elsewhere in the district. And no such proposals are recommended here.
Just, you'll be aware that a number of witnesses to the applicant have commented on your evidence and disagreed with various aspects of your evidence.
Yes.
One of which was Mr. Colgrave, who referred to, I think that your view was that there should be a focus on Greater Christchurch, whereas he was saying, I disagree, you've got to look at the demand at the local level. Have you read his comments in relation to your evidence or not?
Yes, I have, yes, yeah.
And have you any comments to make about specifically that point, namely whether it's not reasonable to have a look at the demand in Prebbleton in this case, rather than Greater Christchurch because of because that's where the demand is?
Yes, yeah. So I think there's a couple of factors here. You know, if you break it down to that extremely small local context and use that as a determinant for whether something provides significant development capacity, both in possibly where I don't necessarily agree with the decision that was made on West Melton. But if you look at that really local level, if you were to, for example, provide 5 houses at Teddington, which is also in Greater Christchurch, in the context of Teddington, that would be significant development capacity. So I guess the point is, where do you draw the line in terms of those local markets and the interchangeability for people to purchase in different locations? And I think my point is that in terms of the NPSUD, I think Schedule 1 of the NPSUD identifies Greater Christchurch or Christchurch City effectively as the urban environment, and that's the context that should be looked at. The NPSUD enables councils to determine how it looks at demand, and in terms of that, the housing capacity assessment looks at it on a district basis. So I guess that's the relevant point that I highlight. And when you look at the figures in terms of the housing capacity assessment, they provide for those supply through to at least the medium term.
Yes, thank you.
I think the other relevant aspect to point out, and I've been involved in, I guess the development of the regional policy statement, the land use recovery plan, and our space in various roles. I think the other point to note that just in terms of the growth in the Selwyn district has been as much a supply issue as a result of the earthquakes as anything. So Christchurch City lost approximately 7,700 homes as a result of the earthquakes. That resulted in the land use recovery plan being essentially pushing through a number of changes that were part of the original, the very original proposed change 1 to the 1998 regional policy statement. And that resulted in a big supply of greenfield land within both Selwyn and Prairie districts. And it's been that supply of greenfield land which has led to a significant number of new dwelling consents that you can see in the upwards trend over the past 5 years. That's whether that growth continues, and Mr. Colgrave uses a sinking lid approach in terms of the likely growth in new dwellings over the next 5 years. Whether that growth, whether you accept that growth should reflect his figures or the projected consents in the housing capacity assessment, that I think that's the key point of disagreement between the two.
Yes, thank you. Yes, thank you, Mr. Langman. I've been very much assisted by that. There may be some further questions which I have, in which case I'll notify you at the hearing if I want to ask any further questions about matters. But in the meantime, anyway, thank you for attending, and we'll now move on to the next witness. Thank you.
Thank you, sir.
Thank you, Mr. Wakefield. So what do you think? I don't know whether we need a break now or we've got yes. Murray and Julie Fletcher. Would you like to? How are we going for time? Actually, I think it's 12:53. I'm just not sure what time we were meant to be having a break. So I think what we'll do, we'll start your evidence and then we'll have a break after you've given your evidence before I ask the questions. Right. Thank you. So just pause there for a minute, would you?
We can hand it round. So that you haven't got it yet, I've bought it. Which
Sorry. Just looking for your submission. Oh, hang on. Oh, sorry, I wasn't here. My apologies. Right, thank you. You start.
All right, thank you. I live at 9 Hyde Place and have lived there with my wife Julie for almost 6 years. We purchased the section in 2015, built our home and moved into our home in June 2016. We chose to buy, build and live in Prebbleton due to its village nature and lifestyle. The section that we purchased has views to the north, east and south of a semi-rural nature with numerous trees. The sections immediately to the west of us are 4 hectare lifestyle lots, and that's the Kingscraft area. At the time, the land to the south of Trent's Road was and still is zoned in the plains. Our section is zoned living, and to our west existing development area, Kingscraft Drive. At the time, development to the south of Trents Road was not seen as necessary and was not part of the Selwyn District planning process. We were right with the view that this land would not be developed and our living quality would not be affected in the future by development. The evidence that has been prepared for Plan Change 68 was numerous, both by the applicant, peer reviewers, council planners and submitters. For a lay person who is suitably concerned to make a submission, it is an onerous and near impossible task to read all the evidence and make comment. My initial submission was around traffic, sustainability and how Plan Change 68 will provide the overall development of Prebbleton. In this written submission, I outline additional comment and concern how that additional evidence has been provided. While I am opposed to Plan Change 68 for various reasons, if Plan Change 68 was approved, there are several changes that could be required that will greatly enhance the development and while not complying with documents like airspace and Climate Change Response Zero Carbon Amendment Act 2019. These may alleviate some of my concerns. The structure of my evidence, I intend to make comment of various issues and concerns. Of some issues, my concerns are supported by evidence, from others which I will reference. In some cases, as I am a lay person and not a lawyer or planner, I cannot reference development planning objective or reference to a particular piece of legislation. However, I trust that you will view my comments and concerns with due respect, as I'm sure you will. And I've just listed here the sections that I'll just speak to, which developers' motivation for Plan Change 68 economics, compliance with airspace and planning documents, urban design, landscape and visual impact assessment, transport and sustainability and relief source. The developer's motivation for Plan Change 68 and the economics. Land values are increasing and there are substantial profits to be made. I have no concern with a business making a profit, but it does concern me where a business seeks to change the rules for it to profit at the expense of others. In this case, the immediate landowners on the north side of Trents Road, including ourselves and the wider Prebbleton community. The evidence of Adam Thompson in his economic assessment, firstly in his report, page 10, figure 5, secondly, page 18, figure 5, suggests significant financial gains if the land is rezoned. While I give a broad brush interpretation, these figures suggest that by merely having the land rezoned from inner plains to living, the land price increases from around $20 per square metre to $100 per square metre. Based on an area of 67.5 hectares, this is an increase in land value of $54 million plus. If the land is then developed into 820 sections, which could in fact be 1,010 sections if the density is increased, at an average sale price of $500,000 per section, then the sale value is between $410 million and $505 million. I have not used Mr. Thompson's figures in his figure 14, as these are clearly out of date, indicating a sale price of $315,000 for 1,000 square metre section. However, I've noted evidence that was provided on Friday by Mr. Sellers, who mentioned or stated that for a 857 square metre section, the land value is more like $570,000, which supports my $500,000. Of course, there is the cost of development, professional fees, infrastructure, contributions, tax, etc. But I am sure that this will still leave a healthy profit. These costs are around $100,000 per section, and the land following rezoning $50,000 per section, leaving a profit of around $350,000 per section. This results in a profit of well over 100 million, maybe as much as 250 million for the entire development. Now I know that what I've stated there is broad brush figures, but it does set the picture. My point is, in my view, this is not about what is best for Prebbleton or Selwyn, but a business opportunity to make a healthy profit. Various planning documents, including airspace, are based on extensive research and set out the future housing requirements and where these should be. Compliance with airspace and other planning documents. Airspace was developed by a partnership of 9 contributing organisations to identify preferred locations for housing growth, encouraging central city and urban centre living while providing for township growth in other centres, especially Rolleston, Rangiora and Waiapoi. Airspace considers numerous factors including population growth, housing demand, sustainability, public transport, and more so where housing for this growth should take place. What is the point of the time and cost developing such planning documents and guidance if they are not followed and are ignored? This and other policy issues are set out in the evidence of Marcus Langman on behalf of the Canterbury Regional Council and the City Council. I support Mr. Langman's evidence and conclusions. Urban design, landscape and visual assessment. The urban design report by Dave Compton-Moen is unhelpful as it does not show before and after visuals. Trents Road is currently tree-lined for most of its length from Oakley Drive to Shands Road, except for a section of fenced farmland on the south side of 150 metres long and the first 130 metres on the north side from Oakley Drive, heading west, which has houses fronting Trents Road. The tree-lined road provides a pleasant and calming outlook and contributes to carbon sinking or carbon capture. For the residents on the north side of Trents Road, including our property and others, it also provides a pleasant outlook. As I mentioned earlier in my introduction, this was one of the drawcards of buying and building in Prebbleton. Mr. Compton-Moen provides 2 viewpoint photos, BP4 and BP5, in Table 4, page 16. Sorry, in Table 4, page 16, he states, the magnitude of change will be low. Has Mr. Compton-Moen based this on the fact that the trees will remain, or has he grossly underestimated the visual effect and loss of amenity value removing the trees will result in? Mr. Compton-Moen provides photo BP2 of Hamptons Road. I would agree that the visual effects will be low in this case, as the properties to the north will be developed and those looking to the south will be looking over farmland that is proposed to remain as it is. However, I cannot agree that the magnitude of change for Trents Road is like Hamptons Road. And I've got 2 photographs here. Below I include photos of Trents Road today, which is the top photo, and what it might look like following development of PC 68 is approved. And the photograph at the bottom is Selwyn Road, which is adjoining the Barrington development. And as you see, there is no trees, there's access directly onto the road, and it significantly changes Trents Road and what it may look like in the future.
Whereabouts in Trents Road is that photograph one, David? Have you got this map?
Yeah, well, it's down the Shands Road end.
Yes.
I think the right is, it's just past the, it's probably in front of Mr. Chen's place. Past the nursery, the Pollard's nursery.
Okay, so it's right near the corner.
It's close. Well, it's past. Thank you. Pemberley Drive. So, to be honest, I can't exactly pinpoint it, but it is the Shands Road end.
So it's after Kingcraft Drive anyway, isn't it?
Right.
So it's 41.
Right. Okay. It's just past. No, it's just past Pemberley. Can I approach you with this photo?
Which is that one? I've got that written on here.
41.
Can I approach you with this
Yes,
photo?
yes. Just put a cross on there if you like. Press like that. Just put a cross there. That's what I'm saying. Just here, is it? About there, okay. That's fine. Thank you.
Heading towards the east. That is, while I provide that photo, it's similar for the length of Trents Road down to Oakley Drive. Mr. Cleese in his 42A report, 161, or number 161, states that a significant number of submitters have raised concerns regarding this change in outlook and landscape/village character. And still Mr. Cleese, I agree that the outlook will change. A suburban outlook is not, however, negative. Suburban areas within Sowens townships generally display a high level of amenity, albeit a different amenity and landscape character relative to rural areas. Now this is making myself speaking. Looking at the two comparison photos, does Mr. Cleese still agree with this statement? Mr. Cleese also states in his section 42A report, towards 114, Mr. Collins has likewise recommended that ODP, or the Outline Development Plan, and narrative be amended to better provide for frontage road upgrades to urban standards and associated vision of an integrated footpath network along with improved cycle routes through the site. Why is the fallback position to urbanise, provide curb and channel, footpaths, etc.? Do we want to change photo 1 to photo 2? Firstly, this flies in the face of the Climate Change Response Amendment Act 2019. Secondly, can we not be more creative? Moving on, transport and sustainability. An integrated transportation assessment has been prepared by Adelaide Consultants and reviewed by Flow Transportation Services. Both reports are substantial, containing various tables, figures, and diagrams summarising the results. The basis of any good report is its background data that has been used. With reference to the ABBY report, the background information and traffic projections used and the conclusions arrived at are flawed. With reference to page 11, table 2.1, traffic counts used are from 2017/18 and 2019, therefore are not current at time of writing the report. Traffic count for Springs Road is stated as 2,660 with 6% heavy traffic. Mobile Roads, which is an easily accessible app, established on 13th of June 2021, the traffic count to be 8,995 with 8% heavy at the same location used in the report. That's 3 to 4 times more traffic. Shens Road, the report has 12,886 with 8.6% heavies versus Mobile Roads 14,679 with 9.8% heavy. A more appropriate comparison for PC68 to be used for the Dixon Springs Road is in the village, where the counts are more around 12,000 to 13,000 vehicles per day. The traffic report assumes a growth rate of 2.8% per annum. This is flawed as it does not consider residential growth already approved and underway for Lincoln and Rolleston. And the plan changes to be considered for a further 5,700 new homes, which I think is more like 10,000 new homes, and 7 developments in Rolleston, which will put significantly more traffic on Shans Road. And also there's planned development in Lincoln, which will also put pressure on Springs Road. Mr. Collins, in his report summary, bullet point 1, top of page 20, states, I consider that the ITA, or Impact Traffic Assessment, has demonstrated that the effects of private plan change 68 on the adjacent transport network are acceptable when considered in isolation of other private plan changes. This is a weak conclusion. Firstly, it is based on flaws in the ABBY report. Secondly, it is based on a first come, first served basis. Thirdly, PC68 is not included within the settlement areas, so other plan changes being considered by the Selwyn District Council will not be factoring plan change 68 into any traffic calculations and traffic effects as a result. Mr. Collins also states on the same page, well, there are and will be capacity constraints on the Prebbleton transport network during peak periods. Regional modelling indicates that Shans Road and Springs Road are expected to experience little change in forecast growth when comparing comparing a 2038 scenario with 10,000 additional dwellings more than forecast. This is myself. Living in Prebbleton and witnessing the growth even over the past 5 years, I find this hard to believe. Mr. Cleese, in his section 42A report, clause 116, states, in the event that a number of plan changes are approved, the QTP, which is the Quality Transportation Planners Modelling, suggests that the additional traffic demand will result in movement shifts to alternative, less congested routes into Christchurch. My reply to that is traffic models are not human and need sensitivity checks. There are two main reasons why this statement is flawed. Firstly, there are few, if any, viable alternative routes for Rolleston and Lincoln into Christchurch. Secondly, the model does not know the condition of these alternative routes, for example, the width, pavement condition and geometry. The model simply works on distance and time. So these alternative routes are often less safe, and people tend to speed on them as they have a perceived idea that they need to make up time. These routes are called rat running and are not liked by the residents on them or the local authorities. Mr. Cleese also states in his section 42A report, clause 115, because decisions on the other plan changes in Rolleston and Lincoln have not yet been released, any increase in traffic generated by them is simply speculative at the time of writing. In short, if they are, or mostly declined, which is unlikely in my view, then there is limited cumulative effect. Then myself speaking, this is an odd statement. Maybe he should also state what will be the effect if they are all approved. This statement highlights why there needs to be a plan in place like our space report to clearly set out where land should be developed so there is more certainty for future infrastructure planning. In regard to Mr. Cleese's statement under section 114 of his 42A report in regard to road frontage upgrades to urban standards, I've made comment under urban design, landscape and visual assessments regarding this above. I also note Mr. Cleese's transport conclusions. He makes no reference of the Climate Change Response Zero Carbon and Brackets Amendment Act 2019. Neither does he make any comment regarding public transport. And we've heard before Mr. Langland also mentioning about public transport, the need to consider public transport and the Carbon Amendment Act. The plan change is private motor vehicle based and does not adequately consider the use of walking, cycling and public transport, other than some cursory comments. There should be planning to show how the public transport system can be extended to accommodate the development and the effect that this will have on reducing vehicle numbers and carbon use. The only indication in the outline development plan indicating walking and cycling are two arrows notated as walkway/cycleway from the existing Stirling Park development. There is no indication how 820 plus homes are going to be connected to promote walking and cycling, including safe integration with Trents and Hamptons roads, schooling and Prebbleton and the Prebbleton village. This development will increase the population of Prebbleton by around 40% and is being presented as a simple bolt-on subdivision. Mr. Collins in Table 4 notes, in my view, the funding and implementation of a public transport system is a matter for Prebbleton as a whole, rather than a site-specific matter relating to plan change. This is myself. I thought it was a requirement under the planning rules to consider public transport and climate change. Hampton Road is classified as an arterial road. As such, protection should be in place to protect access to it and promote safety. These protections were not afforded to Selwyn Road bounding the Farrington subdivision, and if you refer back to my reference 22 page, photo number 2. This has compromised Selwyn Road as a ring road for Rolleston, resulting in speeds being lowered and increased safety risks for road users, including pedestrians And this is due to the unprotected, unrestrained access of all those properties now to Selwyn Road. I disagree with Mr. Collins' comments in his transport report, top of page 17, where he says, I am not concerned about direct access to Trents Road. As Hamptons Road is classified as an arterial road, direct vehicle access can be considered during future subdivision consents, as there are district plan rules to manage the effects of vehicle crossings on to arterial roads. Sound speaking, in my view, the effects on Trents and Hamptons Road should be considered as part of the Plan Change 68 application. And just in conclusion, the relief that I ask for is that the proposed Plan Change 68 be declined.
Are you comfortable to come back after the lunch just so I can ask the questions?
I am.
Thank you. We'll adjourn now for 45 minutes, so 2 o'clock. 2 o'clock, is that? So we'll resume again at 2 o'clock. Thank you for your evidence, Mr. Fletcher. Just going to be time to carefully consider it and ask questions when you come back. Thank you. thank you for coming back. 9 Hilda Place, Hyder Place.
Hyder Place.
Hyder Place, yes. I did a site inspection just by myself on Sunday, and I was able to observe that area along there. So you've got to the west, isn't it? Proceeding along Trench Road on the right-hand side towards the Shams Road intersection. You've got basically larger sections, lifestyle, haven't you, on it?
That's correct. Our section's 1,000 square metres, and the ones immediately to
Yes, and you're effectively the start of that development, aren't you? Because behind you, nearer on the other, what's the main road coming in? Springs Road. On the Springs Road side, you've got the more dense development, and then you're the start of the.
Yeah, we're part of the Hillview subdivision.
Yeah.
And we're the last section of the Hillview, and the next sections are King's Craft.
You mentioned that when you bought your section, this may or may not be relevant. I'm asking these questions because I'll consider later as to the effect of the answers. You said that the development of this area we're talking about for the plan change was not part of the Selwyn District Council planning process. Were you aware of that at the time when you bought? Did you go into that at the time you bought your property or not?
We didn't, but we made an assumption, I suppose, that all that land to the south of Trench Road is farmland, and there's nurseries and so forth, and it didn't occur to us that it didn't seem necessary that it would need to be developed.
Yes, right. So, and I've taken the same, you made some comments about, well, compliance with our space and other planning documents. I take it the same applies. You didn't take those into account specifically at the time, but you've heard about them later, is that right?
Correct, but we did take into account that Kingscraft was EDA, which is they're all 10-hectare blocks there. That's immediately to the west of us.
Well, you knew that the blocks, you knew what the character of the blocks on the right-hand side of Trench Road were, of course, because you could see that. Presumably that was that developed at that time or not?
Yes, it was. Yes, developed.
And at the moment, of course, the plan change area does not include those 4 lots which are adjacent, 3 lots of it. I think the Trench Road Gap, I think it's called.
Correct.
And it doesn't include those properties, you know that.
We're aware of that, and we look out to that.
Yes, so at the moment, so there is an issue, which you probably would have gathered, I don't know whether you've been here the whole time, but there is an issue about whether or not that Trench Road, those Trench Road Gap properties should be included in the change.
Correct. I'm aware that
yes, right.
they've applied to me.
So it may, the issue of whether or not I make a recommendation that the change be approved is, of course, something I have to consider after I've heard all the evidence. And I've also got to consider whether or not, if I were to consider that the change, that I would recommend approval of the change, I've also then got to consider whether these other blocks that are not part of the land are subject to plan change, the plan change should be included. And that includes those Trench Road gaps, I call it that.
Yes.
So if I were not to approve those properties as forming part of the change, then you would be looking out onto your view from your house would not change, would it?
Correct. It would not change.
Just finally, I'm just interested to hear or to read in paragraph 5 you read, as you talked about several changes that could be required. You said that will greatly enhance the development and while not complying with documents like our state, the climate change document may alleviate some of my concerns. I didn't know whether you went on to, you quite clearly and I think helpfully explained to me the reasons why you oppose the change, but I'm not sure whether you've gone on to that, have you?
No, I didn't.
Is there some reason why you didn't do that, or because you did mention it in your evidence, that's why?
No, I was probably running out of time.
I know the feeling. Right, so well, perhaps now you're in front of me now, can you just tell me
Yes.
what changes, if I were, and I hasten to add, I've made it very clear I'm going to hear all the evidence, then I'm going to make a decision, not before. But if I were to recommend that the change be approved,
Well,
let's just say that was a possible outcome. What changes do you think I should make to it? Or recommendations I should make?
well, one area is around the Carbon Act bill and public transport. So this development is going ahead, well, it has been proposed without adequate comment on public transport and the Carbon Act bill. I actually take the bus to work, so I'm not being a hypocrite here with talking about public transport. I think the main changes we would...
When you stay with public transport, just at the moment, because the evidence that I heard from the applicant was to the effect that the regional council could be expected to respond to a request to make provision for public bus services, for example, if there was a sufficient population to justify that in a particular area. So the point, what it was suggested was that there'd be an approach to the regional council, and the regional council would then make a decision either to incorporate, to make some changes to, for example, bus routes. And there were two examples of new bus routes given. And secondly, if there wasn't the funding or it wasn't regarded as being economic, then they may then look to impose a rate. But it was suggested that would lead to appropriate public transport.
Yeah, my understanding is that the applicant is to consider public transport, and they've really glossed over it in the application. To say that it could be considered later by regional council, etc., I don't think that is compliant. That they should be considering it now as part of the.
It's a timing issue as far as you're concerned.
Well, it's not so much timing, it's whether it's going to happen or not. Is the subdivision, the subdivision should be catering for the various transport modes, public transport being one, and that is also a contributor to the reduction in carbon.
So you're saying it should be in place now, we should know about it now rather than have to wait for it?
Yes.
Right, that was your first point, the public transport point, and then sorry I interrupted you. You were going on to your second one, I think, weren't you?
Well, the second one was got more than two, but the second one is the carbon bill. So putting in a new subdivision like this, I haven't seen anywhere in any of the evidence, and I did mention that Mr. Langman this morning mentioned about the Carbon Act or Carbon Bill, but there's no comment around how this development, how they propose to meet that act. And I think the act says something like, New Zealand wants to be carbon neutral by 2050.
2024. 2024.
Well,
Maybe it's, that can't be, no, that can't be right, can it? 2040, is it?
not 2040. Yeah, but everybody's supposed to be
Anyway, there's
considering
a date
it.
in the future.
Yeah, everybody's supposed to be considering it with the developments.
Okay, I understand that. Thank you. I've taken note of that. And are there any other matters that?
Yeah.
So those really aren't changes. They're really criticisms of. They are matters which you say I should take into account in support of declining. They're not really conditions I could impose. I couldn't say, well, I recommend that the change be approved subject to the being a proper bus service. I don't know, I suspect I can't do that, but anyway, that's the point you're making.
Yeah. So our main concerns go back to my page 5 and those 2 photographs and the visual effects. So at the moment, Trent's Road is from Shands Road all the way down to Oakley Drive, and even all the way to Springs Road. Actually, it's pretty well developed in trees as well. Certainly from Shands to Oakley, except that short section I mentioned, there's basically tree line each side, and it's a nice environment. It's calming, and as I mentioned, it's holding carbon. And then you look at my second photograph, which is Barrington development outside Rolleston, and it's unpleasant.
Yes,
and if you saw that all the way down,
I mean, to be fair, is photograph 2 shows. Sorry, go back. If this development took place, all those trees on the right-hand side of Trent's Road would still stay there, wouldn't they?
well, it'd be up to the developer. He could
Well,
choose.
no, on the right-hand side, they're not the developers.
Oh, just right, on the north side.
In other words, on the north side, always looking at that
Yeah.
photograph there, my understanding is that's heading towards Shands Road.
No, it's heading wood, so it's heading
I
towards
think
Springs.
you kindly provided me with a cross. I know exactly.
Yeah, it's heading towards Springs Road, sorry.
Oh, sorry, is that the other way around?
Yeah.
Oh, I'm looking the wrong way around.
Apologies.
Oh, I see, you're looking down there, okay, all right.
So we're looking towards the Port Hills. So
Oh, yes, I'm sorry.
the trees on the left, yes, they would remain.
No, yes.
But the trees on the right
Okay.
may remain, but equally the developer could choose to take them all out. And
I understand that.
and the council's planner, or the consultant who was looking at plan change, was also recommending that this area become urbanised and there's access from those sections onto the road, which to me is not acceptable.
Well, so looking at that photograph, then the trees, contrary to what I said before, the trees on the left-hand side would stay, but not on the right.
Correct. So if there was some provision that the easiest way around it is to have limited access onto Trent's Road, which is 1 or 2 access points, and have all those houses, retain the vegetation, and have those houses with internal roading. So the internal roading then takes you to a main road, so there'd only be 1 or 2 entrances onto Trent's Road. And the Stirling Park subdivision, which is there's Lindsay Drive and then Barling Drive, I think it is, the Stirling Park. And that's what they've done on that subdivision. There's no access onto Trent's Road. There's internal access, and it's reasonably pleasant with. I wish I'd take the photograph now for you, but it's reasonably pleasant with the fencing they've got, and they've put plantings in there.
Yes, well, have you seen the outline development plan or not, related to this development?
I've seen it, yes, but it's
And
just that.
there's one only access point onto Trent's Road. Is that right?
No, it's an outline development plan, so they could come along with the subdivision. If this plan change 68 was approved, they can then come along and apply for subdivisional consents and have a row of houses on the south there, all accessing Trent's Road, as has happened at Barrington, and as recommended by the planning consultant.
Well, sorry, there's an outline development plan, and if the council were to approve the change, then it would be on the basis of the outline development plan.
Correct.
But the outline development plan shows one access on Trent's Road, not more than one.
But the outline development plan is simply that, an outline development plan. It doesn't show all the accesses onto onto Trents Road. It shows two main accesses, which the internal roading could access onto, but it's nothing to include them.
Are you talking about the sections on that are adjacent to Trents Road?
Yes,
Going
on the
straight
south side, yes. And the planner, I'll put his name now, is recommending that Trents Road be urbanised, which would mean curb and channeling footpaths and the allowance of those houses on the south side to directly access Trents Road.
So you're saying that, in reality, there'll be a significantly greater number of accesses onto the road than there is at present because of the subdivision?
Correct. Because the outline development plan, it only shows the main roads within the subdivision. It doesn't show all the roads or all the access points.
Well, look, thank you very much for your submissions. Just as a sort of as a comment, I have to take into account a large number of things, of course. And clearly, there are a number of residents who will express displeasure at the fact that there may be change in this area. That is one of the factors I've got to take into account. There are a large number of factors that I've got to take into account to discharge my duty. And essentially, I've got to look at the Resource Management Act and to see whether or not what is promoted by that Act is represented by this proposal. That's putting it very broadly, obviously more technical. So anyway, I thank you for your submission, and I'll take that into account. Thank you.
All right. Thank you.
Now, the next submission I have is Mr. Bowman. Bowman, is he? Not here. Sorry, I can't hear. Yeah, that's fine, no problem. As I say, Mr. Burgess and Angela Phillips. We've run out of submitters. Bear in mind that what's happened is that Mr. Williamson and all those submitters who are associated with him, that's Mr. and Mrs. Summerfield and others, they're going to be heard on Monday next. So have we run out of, are the others expected, are they?
Yes.
Yes, no, you did explain before, so I think we've just got to take a short adjournment. If you want to stay, you're very welcome. But we'll need to wait until the others arrive. I should say that's against the background that we're changing the schedule, and some of them would have been expecting to attend at the nominated time, the times that we first of all scheduled, and of course now that's changed because of the fact that Mr. Williamson and the others aren't giving evidence. All right, so we'll just a brief adjournment until someone else arrives. Thank you. does not wish to attend, which is the same position with Mr. Gary Burgess. Angela Phillips is not available this afternoon. They were the three submitters who were to be heard this afternoon, and she's to be heard on Monday. Now, as far as Mr. Bowman and Mr. Burgess are concerned, I propose directing that they have an opportunity to make written submissions to me, which will be made available to you as well. They'll be on the website, but they're not on the site anyway. So that's where we are. We've now reached the end of the day because there are no further submitters to be heard or no other persons to be heard. So we will be recommencing at 9 a.m. on Monday in this room, and we'll be hearing from Angela Phillips, Nick Williamson, and then Mr. and Mrs. Summerfield and all the others. That will be followed by the presentation of the reports, Mr. England, Mr. Collins, and Mr. Cleggs. Anyone got any questions at all to ask in relation to that? So we can't do anything until then, right? It's just a matter of waiting. All right, so I adjourn the hearing until Monday, and thank you for your attendance. Thank you for your patience. Thank you for your technical help, which was much appreciated.